Thank you. Good afternoon. Please be seated. As the bailiff introduced me, I'm John Carbo. I'll be your presiding judge this afternoon. Welcome to everyone. Of course, we are now in the final round of the Georgia High School mock trial competition. Congratulations to both teams for being here. Let's just go over just a couple of things that you all know. First of all, make sure there's no communication between anyone competing and anyone in the audience. Don't think that needs to be said. Don't believe anyone's wearing any sort of team insignias or colors or anything. That looks good. Well, obviously it's being videotaped by the mock trial office, and I believe being live streamed this afternoon, so that will be done. Remind everyone in the audience to have your phones on silent, and if you need to go out, please step out in breaks if you can in between witnesses or other points. Have the teams exchanged rosters with each other?
Yes, Your Honor.
Yes, Your Honor.
May we use this opportunity to give rosters to yourself and the jury?
That's exactly my next point. Thank you.
May I approach, Your Honor?
You may. Thank you very much. All right, let's start with the plaintiff. If you'll start by, you may make your introductions at this time.
Yes, Your Honor. Good afternoon, Your Honor, ladies and gentlemen of the jury and opposing counsel. My name is Tyler Sprague, and I will be lead plaintiff today. I will be conducting the opening arguments, the direct examination of Dr. Hopkins, and the cross-examination of Ms. Simone Bell.
Thank you, Mr. Sprague.
Good morning, Your Honor, members of the jury, and opposing counsel. My name is Connor Mattice, and today, on behalf of the plaintiff, I will be conducting the direct examination of EMT Charlie Schrader and the cross-examination of Ms. Casey Farnsworth.
Thank you, Mr. Mattice.
Good afternoon, Your Honor, members of the jury, and opposing counsel. My name is Rachel Lee, and today I'll be conducting the direct examination of Mr. Jordan Dillard, the cross-examination of Dr. Tony Friedman. I'll also be conducting the closing arguments.
All right, thank you, Ms. Lee.
Good afternoon, Your Honor, and members of the jury. My name is William Menard, and I will be playing Jordan Dillard.
Thank you.
Good afternoon, Your Honor, members of the jury. My name is Eric Grabsky, and today I'll be playing Dr. Brian Hopkins.
Thank you.
Good afternoon, Your Honor, members of the jury. My name is James Peterson, and I will be playing Charlie Schrader.
We have a timekeeper?
Yes, Your Honor. Good afternoon, Your Honor, ladies and gentlemen of the jury, opposing counsel. My name is Manit Madhusudan, and today I will be timekeeping on behalf of the plaintiff.
All right, thank you. Defense, would you like to make appearances?
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Noah Siegel, and today I, along with my co-counsel, represent the defendant, Casey Farnsworth, and the Miltonville Mini Market. Today I will be conducting the direct examination of Simone Bello and the cross-examination of Jordan Dillard. I will also be reading the deposition of Daniel Green on behalf of the defense.
All right, thank you.
Hello, my name is Empress Haley, and I will be conducting the direct examination of Casey Farnsworth as well as the cross-examination of EMT Charlie Schrader. I will also be delivering opening statements on behalf of the defense.
Thank you, Ms. Haley.
Good afternoon. My name is Lila Didier Sober. I will be conducting the direct examination of Dr. Tony Friedman, cross-examination of Dr. Brian Hopkins, and I will also be delivering the closing argument on behalf of the defense.
Thank you, Ms. Didier. So,
The witnesses for the defense are
Good afternoon. My name is Natalie Goodman, and I am Casey Farnsworth.
thank you.
Good afternoon. My name is Claire Thompson, and I am Simone Bello.
Good afternoon. My name is Ben Hasty, and I am Dr. Tony Friedman.
Thank you.
The timekeeper for the defense is
Good afternoon. My name is Jordan Tagliatella, and I will be keeping time on behalf of the defense.
Thank you. Thank you very much. Timekeepers, you know to work together. You've done this before. if you have at the end of any segment, opening statements, witness segments, et cetera, if you see that you're more than 15 seconds apart and you are not able to resolve the differences, please let me know so we can get those resolved up front so we don't have lingering time issues if we can.
Yes, Your Honor.
Yes,
All right,
Your
thank you. Are there any pretrial matters that the plaintiff would like to address before we begin?
Yes, Your Honor. May we move freely about the well of the courtroom?
This is your courtroom. You may move freely wherever you wish to for your opening statements, your closing arguments, your witness examinations. Approaching the witness, you do not need to ask permission. The only thing I would ask is that you be respectful of the space of the witnesses, especially opponents' witnesses if you approach them.
Yes, sir.
But other than that, free reign for both sides. You do not need to ask.
And where would you like us to place exhibits when they've been tendered in?
Is there there's not a lower bench down here. Why don't we just put them up here on the rail once they're admitted? That way they'll be accessible to both parties.
Yes, Your Honor. Finally, the plaintiff would like to make this court aware that both sides intend to enter into the record portions of the sworn deposition of Danny Green. Now, we've already exchanged highlighted copies with each other, and we have both agreed to do this right after opening statements.
All right, you want to do that before you call any live witnesses?
Yes, Your Honor.
All right, that's acceptable to the defense?
Yes, Your Honor.
Very well.
Now, because it is stipulated under stipulation 25 that Mr. Green is unavailable, Mr. Mattice will be reading the responses, whereas I will be asking the questions on behalf of the plaintiff.
All right, thank you. And are there going to be some questions that the defense is propounding out of the deposition as well?
Yes, Your Honor.
All right, and is it suitable if the same counsel for the plaintiff reads those responses?
Yes.
That in just a moment.
Your Honor, we have also been made aware that the jury has been provided with copies of exhibits. Would you prefer that we still move to publish once exhibits are entered into evidence?
No. Once an exhibit is admitted in evidence, you may publish it at your leisure.
Yes, Your Honor. We would also ask that all pretrial matters extended to the plaintiff also be extended to the defense.
Of course.
With that, the defense is ready to proceed.
Right. If all witnesses at this time will please stand and raise your right hands. Do you promise that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of this mock trial competition? If so, please say I do.
I do.
All right, all witnesses have confirmed. You may be seated. Thank you. Is there anything else in from the plaintiff before we begin with opening statements?
Nothing from the plaintiff, Your Honor.
Defense.
Nothing from the defense, Your
All
Honor.
right, very well, plaintiff, you may have the floor for your opening statement.
Yes, Your Honor. All the defendant had to do was ask. My client's younger brother was killed in a car crash. Danny Green was driving that car. Danny Green was drunk. The beer he drank, he bought at the Miltonville Mini Market. And the seller? Casey Farnsworth. Casey Farnsworth failed to do what a reasonably prudent shopkeeper would do. She did not ask Danny Green for identification. Green was under the legal drinking age, and he did not have a fate. All the defendant had to do was ask. Good afternoon, ladies and gentlemen of the jury. My name is Tyler Sprague, and I, along with my co-counsel of Rachel Lee and Connor Mattice, represent Jordan Dillard, administrator of Rob's estate and his older brother. This is a Dram Shop Act case. We as the plaintiff must prove to you, beyond the preponderance of the evidence, meaning more likely than not, that the defendant unlawfully, willfully, and knowingly sold alcohol to Danny Green, knowing he would be driving soon. There will be no dispute here in today's case that the defendant unlawfully sold that alcohol to an underage Danny Green. Unlawfully. Nor will there be any dispute here today that Casey Farnsworth sold that alcohol of her own volition, willfully. This case rests on whether you believe that Casey Farnsworth did so knowing Green was under the legal drinking age and knowing he would be driving soon. For this, we do not have to prove to you actual knowledge. Rather, we have to prove to you that in the exercise of reasonable care, Casey Farnsworth should have known that Green was underage and would be driving soon. Danny Green, EMT Schroeder, Dr. Hopkins, and Jordan Dillard. They will tell you this tragic tale. Danny Green will testify by deposition. He will tell you that on the day in question, in the evening, he goes to the Triple M to purchase beer. During that interaction, Casey Farnsworth fails to card Danny Green. Green indicates to Farnsworth that he will be going to a party that same evening. And most importantly, Danny drives to and from the Triple Nine. Jordan will tell you what his brother was like. Rob is 18. He's smart and talented, but he's struggling with the death of his parents. On July 31st, 2021, Rob leaves Jordan to go to a party with Danny. Jordan joins them soon later, and this is what he sees. Danny is drinking alcohol. Rob is there too, hanging with his friend Danny. It would be the last time Jordan ever sees his brother alive again. Danny will tell you that after the party is over, Rob gets into the car with him. Danny is driving. A few minutes later, EMT Schroeder gets a 911 dispatch call to a one-car accident. He rushes to the scene and he finds the accident. It's bad. He sees a splintered telephone pole, a badly mangled Ford sedan, and broken glass everywhere. He rushes to the car and he finds a man in the driver's seat. It's Danny Green, and he's unconscious, but he thankfully has a pulse. EMT Schroeder gets Green on a stretcher and he sends him to the hospital. And that's when he sees it. Laying on the ground, only a few feet away, is Rob Dillard, and he's dead. EMT Schroeder sends Rob Dillard to the morgue. At the morgue, Dr. Hawkins examines Rob's body, and he determines the cause of death to be an aortic rupture. He explains how this happened. Danny is speeding. He loses control of the vehicle and collides with a telephone pole. The point of impact is the front passenger side door. Rob is sitting in the passenger seat. The forces of the collision rupture Rob's aortic artery, and he dies in a matter of minutes. Now, after I'm done, Miss Haley is going to get up, and she is going to blame the victim, 18-year-old Rob Dillard. She is going to tell you that he assumed the risk. She is going to tell you that he was driving that car. To do this, they are going to offer the testimony of Ms. Simone Bello, Dr. Friedman, and the defendant, Casey Farnsworth. But pay attention to how reliable their testimony is. In the end, ladies and gentlemen of the jury, all the defendant had to do was act. And because she did not, Rob is dead. Therefore, we ask you to find Casey Farnsworth liable for the wrongful death of Rob Dillard. Thank you.
Thank you, counsel. Defense.
Yes, Your Honor. No knowledge, no warning, no liability. You heard Attorney Sprague tell you that the burden of proof in today's trial rests upon the plaintiff. This means they have to prove that Casey Farnsworth willfully sold beer to Danny Green, knowing he was under the age of 21 and knowing that he was going to drive under the influence of that alcohol. In addition, they have to prove that Danny Green was driving at the time of the fatal accident. Members of the jury, the plaintiff will fail to meet their burden. In order to be liable under Georgia law, a vendor must knowingly, willfully, and unlawfully sell alcohol to an underage person knowing they are going to drive afterwards. Ms. Farnsworth will tell you she did not know Mr. Green was under the age of 21, and she did not know he was going to drive that night. In fact, Georgia law only requires vendors to check the identification of a customer if they would reasonably doubt that customer is under the age of 21. Ms. Farnsworth will tell you she thought Danny Green was at least 25. And while we concede that she was mistaken, you will learn that she used reasonable care in running her business. And furthermore, the plaintiff will not be able to prove that Danny Green was responsible for the death of Robert Dillard, because Danny Green was not driving the car that crashed on July 31st. In fact, the evidence will show that Robert Dillard was more likely driving at the time of the accident. And members of the jury, you will hear no evidence presented today that Casey Farnsworth ever sold alcohol to Robert Dillard. Now, the defense will bring before you 3 witnesses today. And first is Miss Casey Farnsworth, the owner of the Miltonville Mini Market. Ms. Farnsworth will tell you exactly the circumstances under which she sold to Danny Green, and you'll hear her say how regrettably she had no reason to suspect that Mr. Green was under the age of 21. And next, you will hear from Simone Bello, the only eyewitness to the accident. it was in her yard that the vehicle came to rest, and she'll tell you what she saw. She saw the driver ejected from the vehicle. You will learn that Robert Dillard was the only person ejected from the car that night. And finally, Dr. Tony Friedman, a medical examiner with extensive experience in reconstructing car crashes. Dr. Friedman will explain the exact circumstances under which the crash took place and even show a detailed diagram of that crash. Dr. Friedman will explain that Robert Dillard's injuries, the eyewitness testimony of Simone Bello, and the car represented in this diagram all point to the conclusion that Robert Dillard was driving on the night of July 31st, 2021. The plaintiff will also bring witnesses before you, and among them is EMT Schrader, who will tell you that he was working 20 hours into a 24-hour shift before arriving on the scene and throwing together a sketch of what he remembered at the end of the night. You will hear from Dr. Hopkins, but Dr. Hopkins will admit to conducting the autopsy of Robert Dillard under the assumption that Danny Green was driving that night. Dr. Hopkins will admit to not requesting for additional information such as blood or hair from the vehicle. And you will learn that Danny Green had injuries on the right side of his body that are consistent with him sitting in the passenger's seat. And finally, Jordan Dillard, who has undoubtedly suffered a tragic loss. But Jordan will not be able to tell you how the car crashed that night or even who was driving. Jordan only knows who to blame, Casey Farnsworth. But you will learn that Jordan was in the Miltonville mini market with Danny Green prior to the night of July 31st. And Jordan watched as Danny bought beer from Miss Farnsworth, knowing how old Danny Green was. Jordan will admit to doing nothing. And Casey Farnsworth will tell you she would have never knowingly sold alcohol to an underage person, but she did not know. And no one, especially Jordan Dillard, warned her. All Jordan had to do was tell Casey. At the end of this trial, my co-counsel, Attorney Didier Sober, will come before you and ask that you return the verdict that truth demands and justice requires. That with no knowledge and no warning, Casey Farnsworth is not liable. Thank you.
Thank you very much, counsel. When you're ready, plaintiff, make all your first witness.
Yes, Your Honor, at this time, we would like to enter into the record portions of the deposition
All right, that will be the deposition of,
of Danny Green, Your Honor.
very well. And I believe your co-counsel is going to read the answers from the witness stand.
Yes, Your Honor.
All right, if you'll take the witness stand.
We've already exchanged highlighted copies with opposing counsel. Would you like one yourself?
I'll trust that if we get beyond the bounds, opposing counsel will object appropriately, but I really don't need a copy. You may
Yes,
proceed.
Your Honor.
All right.
And additionally, because this is going to help contextualize to the jury what's about to happen, we asked to read stipulation 20 into the record pursuant to
You may
special
do so.
law report.
You may read stipulation 20.
Exhibit 9 is a true and correct copy of excerpts of the deposition transcript of Danny Green, taken while he was incarcerated at Johnson State Prison, Wrightsville, Georgia. The parties stipulate that these excerpts are the portions they would offer into evidence, subject to objections. However, objections as to the form of the question are waived.
All right, that stipulation is noted for the record.
Thank you, Your Honor. Please turn to page 76. On July 31st, 2021, how old were you?
20.
Now, moving back to the first page. Before you arrived at the home of the Hasselhoffs, did you stop anywhere from the time you left your own home?
Yes.
Tell me where you stopped.
At the Miltonville Mini Market. The Triple M, I call it.
Did you purchase anything at the Triple M?
Yes. Beer.
How much beer?
2 6-packs. Tall boys.
By tall boys, do you mean the 16-ounce cans?
Yes.
Flipping the page, did you show an ID when you bought the beer on July 31st at the Triple M?
No, they didn't ask.
Who didn't ask?
Casey Farnsworth, the one who was at the register and sold me the beer.
Now, flipping to page 79, when you went to buy beer at the Triple M on July 31st, how did you get there?
I drove.
What kind of car?
2018 Ford Focus RS.
What time did you arrive at the home of the Hasselhoffs?
It was a little after 9 p.m.
What, if anything, did you bring with you?
The beer I had bought at Triple M, a bag of chips from home, and that was all.
How many beers did you end up drinking?
Over the entire time I was there, probably around 9 or 10.
How long were you there?
5 hours, more or less.
Now flipping to page 85. Tell me about leaving the party with Rob.
By around 2 in the morning, most people had left, and most of the food and beer were gone. Rob was a little wasted, and I offered to give him a ride home.
Your Honor, may I be heard?
You may.
Your Honor, no foundation has been laid as to what in Rob Dillard's behavior caused Danny Green to believe that he was a little wasted, as it is not Danny Green's rationally based perception that Rob Dillard is wasted. It is therefore speculation, and I object.
You may respond.
Your Honor, Danny Green, as a lay witness, can make a rationally based perception as to whether he perceived that Rob Dillard was drunk or not.
Do you believe you've laid the foundation that he was in a position to render a lay opinion based on his rationally based perception?
Yes, Your Honor.
How so?
Because we've asked questions relating to how they were at the party.
Right? You may respond.
Your Honor, just because they were at a party together does not mean Danny Green has personal knowledge as to how much alcohol makes Rob Dillard intoxicated, or specifically what in Rob Dillard's behavior indicates that he is intoxicated as opposed to normal behavior.
All right. I will overrule. You, of course, may cross-examine on those points if you wish.
Yes, Your Honor.
Yes, Your Honor. Tell me about leaving the party. Sorry. What did Rob say?
He initially said no, but I said we could talk about Lexi during the ride, so then he said yes.
Who drove?
I did. Like I said, Rob was kind of wasted.
And were you driving the entire time from leaving the house until the crash?
I don't remember. I was driving the entire time I can remember, but at some point, about a mile before the crash, I can't remember anything else. The next thing I knew, I was waking up in the ambulance on the way to the hospital.
Well, you have no memory of ever stopping the car to let Rob drive, correct?
Correct.
Now, returning to page 76. How did you know Casey Farnsworth?
Ms. Farnsworth was there many times, more than half the times when I went to Triple M, and we would chat a little bit.
Had you bought beer at the Triple M before?
Yes.
How many times?
Don't know the number exactly.
But it's safe to say at least 20.
Yes.
In the 20 or more times you bought beer at the Triple M, were you ever asked for identification?
I don't think so.
You don't know?
I don't remember ever being asked for ID.
And all of these 20 or more times we're talking about, did they happen before your 21st birthday?
Yes.
Did you have a fake ID?
Not during the time I was buying a beer at Triple M, no.
What would you have done if the sales clerk had asked for ID?
Since it never happened, I don't know what I would have done. I might have said I didn't have it on me, but I never asked for ID, and I never gave them one.
In the 20 or more times you bought beer at the Triple M, did you ever walk there?
No, it's too far from where I live, 3 or 4 miles. I always drove there.
No further questions, Your Honor.
All right. You may present your cross questions from the deposition.
Yes, Your Honor. I am now approaching Attorney Sprague with the highlighted copy of the deposition for the defense.
It's Matthijs.
Matthijs. Are you prepared?
Yes.
I want to focus on what happened leading up to the crash that killed Rob. How well do you remember that evening?
Pretty well, up to a point, and then not so well.
Could you explain what you mean?
I remember getting together with a group of friends at the Hasselhoff's place. I remember hanging out with the group for a few hours. I remember that Rob was there, among others. I remember getting in my car with Rob, and I remember driving for a while.
Please turn to the next pink tabbed page. Are you there? During that time after midnight, did you and Rob talk?
I'm sorry, I'm a little confused.
Page 84.
Oh, sorry. It's on 85. Yes,
About what?
Lexi.
Can you be more specific?
He was mad that Lexi had gone with me to get burgers.
Turning to the next page. And were you driving the entire time from leaving the house until the crash?
I don't remember. I was driving the entire time I can remember, but at some point, about a mile before the crash, I can't remember anything else. The next thing I knew, I was waking up in the ambulance on the way to the hospital.
Page 86. I'll ask it this way. Did you ever see Rob doing drugs?
Objection,
Yeah.
Your Honor. Pursuant to Rule 404, this is propensity evidence. It is inadmissible. Additionally, I'd ask that under Rule 403 you apply the balancing test, because this evidence it causes unfair prejudice to Rob Dillard, which substantially outweighs its scant probative value.
Response.
Yes, Your Honor. Under Rule 404, this should come in for two reasons. Reason number one, under Rule 404B2, this is evidence of Rob Dillard's identity, knowledge, and behavior. As this is evidence that Rob Dillard had a habit of acting recklessly when upset, it is therefore evidence that as he was upset the night of the party, he would be more likely to drive recklessly. In addition, under Rule 405B, this is a specific instance of conduct which may be used as character evidence if it is an essential element of a charge, claim, or defense. As it is an essential element of our defense that Rob Dillard recklessly chose to drive, it is therefore this specific instance of conduct is admissible under Rule 405B2. These two factors, meaning that they make it more likely for Rob Dillard to drive on the 31st and the morning of August 1st, mean that it is therefore more probative than prejudicial.
I believe the question was, did you ever see Rob use drugs, correct?
Yes, Your Honor. If I may proffer?
You may.
This is going to be a chain of questions in which it becomes clear that Rob Dillard had a habit of acting recklessly, particularly, unfortunately, when he was upset, which he was the night of the party.
You may close on your objection.
Your Honor, Rob's use of drugs does not pertain to that line of questioning, so I'd ask that that be stricken from the record and that they move on to the questioning they're referring to.
I'm going to sustain on the use of drugs.
Yes, sir.
You may proceed to your next question. If there's another objection, we'll address that.
Yes, Your Honor.
Yes, Your Honor. Do you know what mailbox baseball is?
Yeah.
Objection, Your Honor. I object on the same basis as before. Under Rule 404, this is propensity evidence, and I'd ask that you apply the balancing test.
Response.
Your Honor, this is violent behavior, particularly associated with making dangerous decisions while in a car. If I may proffer, mailbox baseball is when a person leans out of the window and hits mailboxes with a baseball bat. This is specifically reckless, violent behavior related to driving, and therefore makes it more likely that Rob Dillard would choose to exhibit reckless behavior related to driving on July 31st.
Why would this not be improper propensity evidence under 404B1?
Your Honor, under Rule 404B2, character evidence is admissible if it goes to prove specific things. In addition, under Rule 405, it is admissible.
What does it fit under 404B2?
Under Rule 404B2, this is motive and identity. Crimes, wrongs, or other acts, character evidence may come in.
Response.
Your Honor, I don't understand how this goes to the motive of Rob Dillard nor the identity of Rob Dillard.
Does either party believe there'll be any evidence in this case of mailbox baseball?
No, Your Honor.
No, Your Honor.
All right, I will sustain.
Thank you, Your Honor.
Yes, Your Honor. Going to page 87. Are you aware of an incident when Rob kicked a water fountain at school so hard and so many times that the water fountain came loose from the wall?
Objection, Your Honor. I'm going to object on the same grounds as previously under Rule 404B2 or B1. This is evidence of a prior act used for propensity evidence, and I'd also ask that you apply the balancing test again.
Response.
Your Honor, specific evidence of conduct is admissible to prove character evidence if it is an essential element of a claim, charge, or defense.
What essential element are you referring to here?
That Rob Dillard acts recklessly when upset.
And again, I'm going to sustain.
Yes, Your Honor.
Under
Nothing further.
404B1. I'm sorry.
Yes, Your Honor. Nothing further for the deposition from the defense.
All right, thank you. Is there any other evidence from the deposition from the plaintiff?
No, Your Honor.
All right, thank you. You may sit down.
Thank you.
I am now retrieving Exhibit 9.
All right. All right, you may call your next witness, which I guess technically is your first live witness.
Yes, Your Honor.
All right,
Plaintiff now calls Mr. Jordan Dillard to the
all right,
station.
Mr. Dillard, you've been sworn, you may come to the witness stand.
Good afternoon. Please introduce yourself to this jury and tell them how you're related to Rob Dillard.
My name is Jordan Dillard. Rob Dillard was my brother.
Now, could you tell this jury a little bit more about your family?
Well, we're from right here in Miltonville. Parents ran Dillard's Billiards for years up until they passed. My mom in 2020 from non-Hodgkin's lymphoma, and then my dad just 2 months later from a stroke.
And Mr. Dillard, how old were you when your parents passed away?
Our dad passed when just a couple weeks after my 21st birthday.
What about Rob? How old was he?
He turned 17 that year.
And how did Rob take your parents passing away?
I mean, after mom, he was destroyed. He didn't really come out of his room. Then after dad, well, I mean, yeah.
What about you, Mr. Dillard? Were you in school?
I was. I'd been in college at the time, and when our parents passed, I transferred to Miltonville State University. It was close to our house, and it helped Rob finish high school.
Now, Mr. Dillard, we have to talk about Mr. Green. Were you friends with Mr. Green?
I personally was not. Rob was, though.
Well, did you know how old he was in the summer of 2021?
20 years old.
And what about his relationship with Rob? Can you just tell this jury a little bit more about that?
I mean, Rob followed him around like a puppy dog. They were close friends. I never really understood why. I always found Danny a bit immature, but Rob just thought the world of him.
Your Honor, at this time, I'm reproaching opposing counsel for what is previously been marked as exhibit 2.
All right. So that was 6. Exhibit
2.
2. All right, thank you.
Mr. Dillard, do you recognize this?
I do.
What is it?
It's a photo of Danny.
And this is a fair and accurate representation of how Mr. Green looked in the summer of 2021.
It is.
Your Honor, plaintiff now tenders exhibit 2 into evidence, the authenticity of which has previously been stipulated under stipulation 10.
Any objection?
No objection.
All right, exhibit 2 is admitted without objection.
Now, Mr. Green, I want to talk to you briefly about the Triple M. Have you ever been inside the Triple M, Mr. Dillard?
I have.
Your Honor, at this time, I'm approaching opposing counsel with what's previously been marked as exhibit 8.
All right, 8 is noted.
Mr. Dillard, do you recognize this?
I do.
What is it?
It's a sign they have up in the Miltonville mini market.
And is this sign a fair and accurate representation of the sign that you saw in the
Ye-
Triple M?
It is.
Your Honor, plaintiff now tenders exhibit 8 into evidence, the authenticity of which has previously been stipulated under stipulation 19.
Thank you. Any objection?
No objection.
Again, admitted without objection.
Mr. Dillard, can you read aloud what this sign says?
It says, under 30, please have ID ready for alcohol, tobacco, e-cigarettes, and e-vapor purchases.
Your Honor, permission to publish exhibit 2 to the jury.
You may.
So, Mr. Dillard, let's go back to exhibit 2 again. In your rationally based perception, does Mr. Green look like he's over 30?
No, look at him. He looks like a kid. Just, he's no way he's not over 30.
Thank you, Mr. Dillard. Now, I'd like to direct your attention to the night of the incident, July 31st. Was Rob home?
He was.
And did Rob ever leave?
Yeah. We ate dinner that night. We had pizza, and then about 8:30 he left to go to a friend's, Kim Hasselhoff's place.
And did you also leave for the Hasselhoffs as well?
I did. After cleaning up around the house, I mean, our mom always really liked it tidy. I left about 10:30.
And Mr. Dillard, do the Hasselhoffs live far away?
They don't. It's only a couple miles. Really, looking back, I wish Rob would have walked.
Now, Mr. Dillard, so what time did you get to this party?
I got there a little after 10:30. As I said, it's really not far.
And how long did you stay at the party?
I left about 1, so that's 2.5 hours.
Okay, Mr. Dillard. Now, when you got there, who was there?
Well, there was Danny, Rob, Lexi, and a handful of other people.
And were people drinking?
They were.
Was Rob drinking when you got there?
Yeah, he was. I saw him drinking, and I walked over to him, and I asked him how much he'd had. And then he told me I sounded like Mom, and I mean, that was a bit of a gut punch. I mean, losing her still stung, you know?
You also mentioned Mr. Green was there. Was Mr. Green drinking?
He was. He was drinking pretty consistently.
Mr. Dillard, based on your rationally based perception of what you perceived at this party, who was Rob paying the most attention to?
I mean, it had to be Lexi Hasselhoff. I had known they dated during senior year, and I could kind of tell Rob still was a little into her. I thought he wanted to get back together with her, so he had been around her most of the night.
Now, so Lexi was kind of like Rob's ex-girlfriend, am I correct?
Exactly. I mean, you know how teenage romances go, a bit of a love-struck teenager, that whole thing.
Now, Mr. Dillard, did Mr. Green ever leave the party and then come back?
He did.
Objection assumes facts, not evidence. Your Honor, may I be heard?
You may.
She's just suggested that Danny Green took another drive. Mr. Dillard has not brought this up himself, therefore this is assuming facts, not evidence, and in addition leading, which is inadmissible under Rule 611C.
Response.
Your Honor, I'm simply asking this question in order to get to the part where Mr. Dillard was going out for a drive, but if opposing counsel deems necessary, I can rephrase my question as well.
Well, anything in conclusion on your objection?
Yes, Your Honor, this is a leading question. She has suggested this other drive, but if she were to rephrase, I would.
Your Honor, if...
I don't believe it was a leading question. I'll overrule.
Yes, Your Honor.
It's a specific question, but not a leading question.
Thank you, Your Honor. So, did Mr. Green ever leave the party and then come back?
He did. Around midnight, him and Lexi and some other guy went to go get food somewhere and then came back.
Now, how was Rob when Lexi said that she would go with Mr. Green?
Like I said, still kind of into her. She got excited to go with Danny, and he frowned a little, you know.
And how was Rob like when they got back to the party?
I mean, he just walked right over to Danny, who was standing 20 feet away from the car, and they were having a conversation. I could tell Rob was steamed.
Now, Mr. Dillard, when you left the party around 1 a.m., did you ask Rob to come with you?
I did, yeah.
And what did Rob say to that?
He told me he wanted to stay longer, and I didn't want to be overbearing, so I just told him to either get a library or crash at the Hasselhoff's place.
And what did Rob tell you?
Like I said, he said he wanted to stay.
Mr. Dillard, what woke you up that morning?
It was a knock on the door.
Now, did you open the door?
I did.
Who was at the door?
A police officer.
And Mr. Dillard, what did that police officer tell you?
He told me my brother was dead.
No further questions, Your Honor.
All right, thank you. Cross-examination.
Commissioner Mercy?
Back.
Mr. Dillard, I'm sorry for your loss, and if at any point you need to take a break, you are completely able, okay?
Thank you.
Unfortunately, I do need to ask you a little bit about what you know about Robert and Daniel Green. Now, it's true that when someone is over 20, they're not a kid, right?
I mean, it depends, obviously, on what you're calling an old person. Might call a person 20, but no, he's not a kid.
And on direct examination, you stated that Danny Green looked like a kid, right?
I mean, yeah, I did.
Now, Mr. Dillard, it's true that in your opinion, Danny Green looked over the age of 20.
He was 20. He looked a little older than he was.
Right. I want to talk a little bit more about what you don't know about the day of July 31st. Now, you got to the party after Daniel and Robert, right?
Yes.
So you didn't see how much Robert had to drink before you got there.
I did not.
You didn't see how much Robert had to drink at the party.
I had been around the party, so.
But that's a yes to my question. You don't know exactly how much Robert drank at this party.
I can't put a number on it, but I had seen him drink.
Now, you also don't know how much Robert had to drink after you left the party.
That is also true. If I'm not there, I can't really know something.
You don't know how much Daniel had to drink after you left the party.
I do not, but I had heard earlier he had drank a good bit, and I had seen him drinking throughout the
I
night.
didn't ask about what you heard. I asked if you knew how much Daniel Green drank after you left the party, and you do not.
I do not.
Now, you left before the two young men, right?
Yes, we talked about that.
So you didn't see who was driving when they left, did you?
I did not.
You didn't see any of the actual drive yourself, did you?
No, that's what it means when you leave before they leave.
So you don't know how the crash occurred.
No.
Now, I want to talk a little bit more about something you said on direct examination. Now, you saw Daniel Green and Robert Dillard get into an argument, right?
I mean, yeah, Rob looked a little steamed right after Lexi had gotten back.
And it's upsetting to get into an argument with someone that you look up to, right?
I would find it upsetting, yeah.
And like you said on direct examination, Rob followed Danny around like a puppy dog, right?
Yeah.
Now, I want to talk a little bit more about the party on July 31st. Now, you believe this crash happened in large part due to underage drinking, right?
I think it happened because your client sold Danny alcohol and he crashed the car.
So you would say yourself that underage drinking is dangerous, right?
I mean, if you're driving, yes.
Now, you knew that there was underage drinking at the party on July 31st, right?
I did, yeah.
In fact, this was a party meant for the graduating class of 2021, wasn't it?
Yeah.
And it's true that the average senior is around 18 years old.
I think so.
And at this party, intended for underage people, there was a cooler where anyone could take out beer, right?
Yeah, I mean, I wasn't throwing the party, I just went there.
So, despite the fact that you knew that there was underage drinking at this
Objection, Your
party-
Honor, and I have two bases for my objection. First, pursuant to Rule 403, this is more abusive than it is probative. As Mr. Dillard's conduct that night or negligence in not trying to stop the underage kids from drinking is not at issue in this case in particular. And therefore, under 403, that would also unnecessarily confuse this jury on whose liability this case is really about, as the jury charge will say that this case is, that they are to focus solely on the liability of the defendant and Miltonville Mini Market Incorporated.
Response.
Your Honor, as to 403, the basis of this case is knowledge and notice. Whether or not Casey Farnsworth is liable is dependent on whether or not she knew or had reason to know about the underage drinking based on her product. As Jordan Dillard knew about the underage drinking and did not tell anyone, this goes to notice, which is an essential element of this case.
Your Honor, may I respond?
Let me make sure I just clarify. Because, say that one more time, please.
Because notice is an essential element of
Sure.
this case.
All right, I get you. All right, thank you. Response.
However, what I am trying to say is Mr. Dillard's notice in this case is not truly what this case is essentially about. What this case is about is Ms. Farnsworth's notice, and therefore Mr. Dillard's notice would simply unnecessarily confuse the jury under Rule 403, and it would also just be needlessly time wasting.
Your Honor, may I respond?
One more time.
Any notice is relevant in today's case and more probative than prejudicial. Simply because it is Mr. Dillard's notice does not mean it's any less important than anyone having the capacity to notify Casey Farnsworth and choosing not to.
I'll overrule.
Yes, Your Honor.
Yes, Your Honor.
Now, you knew there were coolers laying around with beer that any of these underage people could take out of.
I believe there was a cooler.
Despite knowing that, you never told anyone other than Rob to stop drinking underage. Did you?
Objection, Your Honor. Again, I have to raise my objection based on the same basis. But for this time, since Mr. Dillard was not responsible for anyone other than Rob, surely Rob was he was Rob's legal guardian. So I see where opposing counsel may have their point on that. However, to all the other people who were present at this party, this would simply confuse the jury on the fact that they have to consider Mr. Dillard's negligence in not caring for the other underage people at the party, which again is not what they're instructed to do in the jury charge today.
You may respond.
Yes, Your Honor. This case is about whether or not it was reasonable for Casey Farnsworth to not have known that Danny Green was underage and drinking underage. As Jordan Dillard knew that there was underage drinking going on and chose not to notify or do anything to stop it, this goes to whether or not it was reasonable for Casey Farnsworth to know or expect that underage drinking.
How do you contend that what this witness saw or perceived would be relevant to what the defendant saw or perceived?
This case revolves around the sale of alcohol to underage persons. As he knew about it and chose to do nothing to stop it, including not telling Casey Farnsworth, all action that he took revolving around this alcohol, knowing who had it and choosing not to say it, is relevant in the case of notice.
Your
That's
Honor,
fine.
may I?
You may.
As opposing counsel stated, this case is about the sale of alcohol. The sale of alcohol which Ms. Farnsworth made. not Mr. Dillard, which means that his negligence in this case should not be taken into account. And therefore, all this line of questioning would simply go to unnecessary confusing the jury on what the actual issue is that they must focus on this case.
I will sustain the objection on,
Yes, Your
on
Honor.
the confusion grounds.
Yes, Your Honor. You never told anyone that there was underage drinking happening at this party, did you?
I don't remember if I did or not.
It's your testimony that you don't remember whether or not you told anyone there was underage drinking at the party, Mr. Dillard?
I mean, it's been years since the party. I have no idea. I can't remember if I've talked about it to people or not. I mean, we're clearly here, so I'm talking about it now.
You also don't remember whether or not you told the police on that night.
Objection, Your Honor. Again, this is simply trying to place the responsibility on Mr. Dillard, which I believe you have already sustained the objection to.
I'll allow you to respond.
Your Honor, you previously ruled that testimony regarding who Mr. Dillard told about the underage drinking is admissible, while I understand that testimony regarding what Mr. Dillard did in response to the alcohol is not admissible.
You may conclude.
Your Honor, I'll ask the whole line of questioning trying to blame the responsibility on Mr. Dillard be stricken out, or opposing counsel moves to their next line of questioning, as again.
Constructively outside the presence of the jury, proffer to me what you believe the significance of this line of questioning is.
The significance of this line of questioning is that Jordan Dillard knew there was underage drinking happening at this party and chose to tell no one that could stop it. The fact that it was reasonable that Jordan Dillard could have informed people and chose not to will help the jury in making their decision as to whether or not it was reasonable for Casey Farnsworth not to have known.
Tell me how you make that connection.
Well, as Mr. Dillard chose not to inform anyone, it is reasonable to assume that Ms. Farnsworth was not informed by anyone else, and that Mr. Dillard had no grounds to raise the issue of underage drinking prior to the lawsuit against Casey Farnsworth.
All of this would have happened, just correct me, do you believe that the evidence will show that the events you're questioning now would have been after the alcohol would have been sold at the store?
Yes, Your Honor.
You wish to add anything on that?
Your Honor, again, this literally goes to Mr. Dillard's negligence alone, and what we have to consider in this case is only Ms. Farnsworth's negligence. And
You are not raising a defense, or are you not raising a defense that this witness was somehow negligent?
No, Your Honor, but it is relevant that he knew and chose not to tell anyone.
I'm going to sustain the objection.
Yes, Your
Yes, Your
Honor.
Honor. I want to talk about the occasion 3 weeks prior to July 31st. You saw Casey Farnsworth sell alcohol to Danny Green, right?
Without IDing him, yeah.
And when you asked Danny Green about buying alcohol without ID, he said, "I just look old enough." Isn't that right?
I mean, he said he just looked old enough, I guess. Yeah.
And in your opinion, as you said earlier, Danny Green looked over 20, right?
He looked older than he was.
And how old he was 20, right?
During the incident, yes.
So despite knowing that Danny Green looked old enough to buy alcohol, you didn't tell Casey Farnsworth that
Objection, Your Honor. Again, on the same basis, this is trying to blame the whole thing on Mr. Dillard for Ms. Farnsworth being negligent, which, again,
Response.
Your Honor, this is directly pertaining to whether or not Jordan Dillard informed Casey Farnsworth that Danny Green was buying alcohol underage.
Your Honor, by suggesting that Mr. Dillard failed to inform Ms. Farnsworth, this is simply going to question Mr. Dillard's liability in this case. Again, not the probative issue.
I will allow for the limited purpose of the effect on the defendant if the jury finds that that is significant in this case, but for that limited purpose only.
Yes, Your Honor.
You didn't tell Casey Farnsworth that Danny Green was buying alcohol underage on that day, did you?
I mean, to be honest, I just thought she would ask. I didn't. I was just expecting Danny to pull out a fake or something, but obviously he didn't.
You didn't go back on a later day to tell Casey Farnsworth that Danny Green had purchased alcohol underage, did you?
Again, no, I didn't. That's not my job.
You never informed the authorities that Danny Green had purchased
Objection, Your
alcohol.
Honor. Again, on the same basis. I thought this was a very tight line of questioning that you allowed, and I'd ask opposing counsel to move to their next line of questioning that does not blame Mr. Dillard.
Response.
Your Honor, whether or not the authorities were alerted to stop Casey Farnsworth from selling alcohol to a minor is absolutely going to whether or not Jordan Dillard used any mechanism to provide notice to Casey Farnsworth.
I think that question has been asked, and that was the limited purpose that I allowed it. I'm sustaining on the other grounds of anything that occurred subsequent to that night or that incident.
Yes, Your
Yes, Your
Honor.
Honor.
You never told Casey Farnsworth at any opportunity that she had sold alcohol to someone underage, did you?
Not that I can remember.
And to be clear, when you saw Rob Diller drinking alcohol that day, you saw him drinking out of a bottle, not a can like Danny Green.
That
right?
is correct.
Thank you. No further questions, Your Honor.
Thank you. Redirect.
No, Your Honor.
All right, thank you. You may sit down. Give us just a second. Defense, plaintiff, you may call your second witness.
Thank you, Your Honor. The plaintiff calls Dr. Hopkins to the stand.
All right, Dr. Hopkins.
Good afternoon, Dr. Hopkins. Could you please state your name and occupation for this jury?
Afternoon. My name is Dr. Brian Hopkins, and I'm the Deputy Chief Medical Examiner here in Milton County.
In your capacity as the Deputy Chief Medical Examiner, did you perform an autopsy on Rob Diller?
I did, yeah.
And based on that autopsy, did you form a conclusion as to the cause of Rob's death?
Yeah, I did.
Now, before we get to your conclusions, I'd like to talk a bit about your education, training, and experience in forensic pathology. Where did you go to medical school?
I'm proud to say that I graduated from George Washington University in D.C.
After you graduated, did you continue your training?
I did, yeah. For most medical professionals, the internship and residency is just as important, if not more than the degree, so I stayed in D.C. to do both of those.
Are you licensed to practice medicine in the state of Georgia?
Of course.
Are you board certified?
Of course.
Now let's get into a bit more specifically about your experience and training as a forensic pathologist. How long have you been in the field of pathology in general?
About 26 years now.
How many autopsies would you say you've conducted?
On my own, about 3,000, I think.
Have you received any specific training in any specialized fields?
Yeah, I have, specifically to work as a forensic pathologist. Biomechanics and occupant kinematics are two fields which I use pretty frequently.
Could you explain a little bit about what biomechanics is to this jury?
Sure. Biomechanics, to put it simply, is basically the way forces and objects interact with the body, so basically just the way injuries occur.
What about occupant kinematics?
Well, it's the kinematics of occupants, so it's the study of forces and movement of occupants inside the vehicle.
Do you use both occupant kinematics and biomechanics in your day-to-day job?
Yeah, I do, a lot.
How so?
It's just a huge part of the work that we do here as a forensic pathologist, and to be honest, people here aren't the greatest at driving.
Prior to today, how many times have you come to court and testified to render your opinions as a forensic pathologist?
About 100 by now.
And do those opinions often require your expertise in biomechanics and occupant kinematics as well?
They do, yeah, like I said, it's a huge part of my work.
Your Honor, at this time, the plaintiff tenders Dr. Hopkins as an expert in forensic pathology, biomechanics, and occupant kinematics.
Any objection to him being qualified as an expert in any of those three fields?
Yes, Your Honor. While we do not object to Dr. Hopkins being tendered as an expert in forensic pathology, we would object to him being tendered as an expert in biomechanics and kinematics, as the proper foundation pursuant to Rule 702 has not been laid. The only thing Dr. Hopkins has actually testified to is some vague training in the fields, and this vague training is not enough to qualify him as an expert witness in such a scientific and technical field as biomechanics and kinematics. The only other thing he has cited is that he has given expert testimony in those areas, but he has not given us any number as to how many times he has testified as an expert in biomechanics or kinematics, or any of the details of those cases. The proper foundation has not been laid.
Response.
Your Honor, pursuant to Rule 702, we've already established that Dr. Hopkins has training and experience and skill in occupant kinematics and biomechanics as he applies them in his day-to-day job as the Deputy Chief Medical Examiner. Additionally, in order to be a forensic pathologist, he needs to be an expert in those fields. And if he's an expert in forensic pathology, then it's safe to say that he is an expert in the other two as well.
All right, you may close on your objection.
Your Honor, just because Dr. Hopkins may occasionally use areas of biomechanics and kinematics in his work as a forensic pathologist does not mean that he has the qualifications to be entered as an expert in those fields now.
I'm going to overrule the objection. I'm going to find that those points will go to the weight of his testimony, not his admissibility as an expert. Again, you may cross-examine
Yes,
him
Your
on those
Honor.
points. You may proceed.
Thank you, Your Honor. Now, Dr. Hopkins, I'd like to talk to you a bit about the autopsy you performed on Rob Dillard. I'm approaching opposing counsel with what has been previously marked as Exhibit 5. And I'm approaching the witness with the same.
All right.
Dr. Hopkins, what is that?
This is the autopsy report that I wrote after conducting the autopsy of Mr. Dillard.
Your Honor, at this time, the plaintiff moves to tender Exhibit 5 into evidence, the authenticity of which has already been stipulated.
Any objection to
No,
five?
Your Honor.
Admitted without objection.
Now, Dr. Hopkins, what were the major findings of your external examination of Rob?
Externally, Mr. Dillard had severe lacerations and abrasions on both sides of his body, and he had glass shards embedded on the right side of his face.
What about the major findings of your internal examination of Rob?
Mr. Dillard had very severe internal bleeding. Specifically, there was 1,250 cc's of blood in the left chest cavity, with another 100 in the right and another 200 in the abdomen. I later found the cause of that to be a lacerated aorta, which Mr. Dillard had, and on top of that, I also found on its own lethal subarachnoid hemorrhage.
What can cause something like a lacerated aorta?
A lacerated aorta is an acceleration-deceleration type of injury, so basically, if the body's moving one way and then suddenly stops or changes directions, the organs inside, like the aorta, will keep moving in that original direction, and that can cause ligaments to tear, which is what happened in Mr. Dillard's case.
You also mentioned something about a subarachnoid hemorrhage. What is that?
A subarachnoid hemorrhage is basically when blood gets underneath the arachnoid membrane, which is one of the three membranes that surrounds and protects the brain and spinal cord.
Based on your autopsy that you performed on Rob, did you form an opinion as to the cause of his death?
I did.
And are all your opinions given here today to a reasonable degree of medical probability?
Of course.
Could you please share that opinion for this jury?
Mr. Dillard's primary cause of death was loss of blood due to the lacerated aorta, with the secondary cause of death being the subarachnoid hemorrhage.
Now, let's move on to something else, Dr. Hopkins. As I'm sure you're aware, the position of the occupants within the vehicle is at issue here today. Were you originally concerned with that?
Not at the time I did my autopsy, no. When I do an autopsy, it's basically just fact-finding, so it was only after the question was raised about the position of the occupants, and it was only then that I ultimately came to conclusions based on that.
What evidence did you review to come to your conclusion?
Just before testifying today, I reviewed my autopsy report, the photos taken during the autopsy, the photos of the crime scene, the accident reports, the statements of Charlie Schrader and Miss Simone Bello, as well as the deposition of Daniel Green and Daniel Green's medical records.
Based on all that evidence that you reviewed, did you form an opinion as to who was driving the vehicle when it crashed?
I did.
Could you share that opinion?
Daniel Green was driving at the time of the collision.
Thank you, Dr. Hopkins. And based on the position of the occupants in the vehicle, how did Rob Dillard sustain his life-ending injury?
For the lacerated aorta, it would have, the only time it could have happened was during the initial stages of the collision, as that's the only time there were the forces necessary to cause that. For the subarachnoid hemorrhage, which on its own is lethal, to be blunt, it requires a lot less force, so there's more moments during the collision where it could have happened.
Finally, Doctor, I'd like to end with a little bit about you. How much were you paid for your testimony here today?
Nothing.
No further questions, Your Honor.
All right, thank you. Cross-examine.
Yes, Your Honor. Good afternoon, Dr. Hopkins. On your direct examination, you testified that you reviewed photos of the scene of the accident.
That was part of what I reviewed, yeah.
This was an important piece of evidence.
It was part of what I reviewed. Probably the biggest part in me coming to my conclusions was the
Doctor,
relative injuries.
the photos of the scene that you reviewed were an important piece of evidence.
They were part of what I reviewed.
You made a statement for today's trial,
That's right.
and you signed that statement saying you had nothing of significance to add.
That's right.
And you had up until this morning to edit that statement and make any changes,
I did, yeah.
showing opposing counsel what has previously been marked as Dr. Hopkins' affidavit. Dr. Hopkins, I'm showing you your affidavit. I'd like you to read silently as I read aloud line 60. In August 2021, as part of my official duties, actually we can skip ahead to line 63, I also reviewed the medical records of Danny Green so that I could evaluate the relative injuries of Mr. Green and Mr. Dillard to determine who was driving. I reviewed the deposition testimony of Mr. Green, the statements of Charlie Schrader, Simone Bello, photos taken of the vehicle, photos taken during the autopsy, the police report, and materials created by first responders, and the diagram created of the scene. Dr. Hopkins, nowhere in there do you say you reviewed photos of the scene.
Yes, I reviewed the materials created by the first responders.
This would be something like a diagram.
That along with photos, yeah.
You nowhere in here specifically say you reviewed photos of the scene of the accident, do you?
Well, photos of the scene of the accident were
Dr.
materials
Hopkins, I'm
created.
asking what you specifically wrote in your witness statement. Nowhere did you say you reviewed photos of the scene.
No, because it's included in the materials that were created by first responders.
I'd also like to talk about the credentials you claim to have in biomechanics and kinematics. Now, in your direct examination, you testified you had training in these fields.
I did, yeah.
But it's true, you're not certified in biomechanics.
I didn't end up actually receiving the certifications in those fields. It's a big part of the
But you're
work that
not-
I do, and it wasn't really
Dr.
necessary to
Hopkins,
get that.
you're not certified in kinematics either.
Occupant kinematics, I believe you're referring to. Again, it wasn't really necessary to do the work that I do.
Additionally, you've never published in biomechanics.
No, I'm a forensic pathologist. The work that I do is
Redirecting
examining
you back
bodies.
to my question, you have never published in the field of biomechanics.
Like I said, no, I haven't. It's not part of the work that I do.
You've never taught biomechanics,
No, I'm a forensic pathologist.
never taught kinematics.
Again, I'm a forensic pathologist, deputy chief medical examiner. I don't teach.
That's right, doctor, you're a medical examiner. And as a medical examiner, it was your job to make the autopsy report of Rob Dillard.
It was, yes. I
And
remember that.
you've made plenty of autopsy reports before, haven't you, doctor?
I have.
I want to talk about one particular autopsy report you made while working at Northside Hospital. It's true that at Northside Hospital, a complaint was made about you to the State Board of Medical Examiners.
Objection, Your Honor. I think what opposing counsel is about to refer to is a prior instance of conduct, and under Rule 404B1, that is propensity evidence and is inadmissible.
Response.
Your Honor, pursuant to Rule 611B, I am entitled to a thorough and sifting cross. Dr. Hopkins has been tendered as an expert, and pursuant to a case law boon from Vascular Surgical Associates, disputes as to an expert's credentials and credibility are best explored through cross-examination. This will aid the jury in evaluating the weight they put in the testimony he gives.
Response.
Your Honor, just because it will affect, it is exactly because it will affect the weight of the testimony that it should not be admissible, as it is still propensity evidence, and opposing counsel has not given a reason why it should come in.
Overruled.
Yes, Your Honor, I'm going to ask that question again. You were reported to the State Board of Medical Examiners.
That's right, yeah. About 20 years ago, I made a small mistake in dictation during one of my autopsies, and it ultimately ended up leading to disagreements with my coworkers.
Doctor, you failed to log that your patient was missing one of their internal organs.
That's right. The patient had their spleen removed due to COPD some years earlier, I believe, and
Doctor,
I forgot to
redirecting you
dictate that.
back to my question, you did not log your patient was missing their spleen.
That's right.
And after this failure, you left Northside Hospital.
Yeah, I did ultimately end up leaving Northside Hospital. There was a bit of a toxic work environment, so I ended up receiving training under
left?
Dr. Jack Burton, who's one of the
You
greatest
had
forensic
to
pathologists in the
complete
country.
remedial training under Jack Burton.
I did ultimately end up receiving training in forensic pathology under Dr. Jack Burton.
In fact, you had to do 20 supervised autopsies.
Again, yeah, I did ultimately end up
And Doctor-
receiving training, and part of that was supervised
Doctor, I'd like to
autopsies under
redirect
Dr.
you back
Jack
to
Burton.
my question. After you completed these 20 supervised autopsies under Jack Burton, Jack Burton himself asked you to do 2 more years of additional training.
He did ultimately give me that opportunity.
Of course, you know now, Doctor, autopsy reports should consider all information.
All the information on the body, yeah.
In your line of work, it's important to consider all evidence.
Yeah, that's right.
And it's important so you can come to an accurate conclusion.
Yeah.
And I want to talk about the evidence you didn't have when you came to your conclusion in today's case. It's true that there was no hair collected at the scene.
No. In this case, there wasn't any forensic evidence collected from the vehicle. I'd be more than happy to explain why that is, if you'd let me.
It's true, Doctor, that collecting DNA evidence from, say, the driver's seat could have helped pinpoint who the driver was.
Honestly, not really. Again, I'd be more than happy to explain why that is, if you'd let me.
That's not necessary, but Doctor, truthfully, you don't know what DNA evidence could have revealed because no DNA evidence was collected at all.
Again, even if DNA evidence was collected, it wouldn't have been entirely useful, which I believe you said you don't want me explaining, so I won't at the moment.
Your attorney can redirect you on that, but it's true, it is your office's duty to collect evidence.
What I do is I work as a forensic pathologist, and I use
Doctor,
the
I'm
evidence given
asking
to
you
me.
about your office's duty. It is true, your office has to collect evidence.
That's part of what they do.
And no one from your office collected any DNA.
Again, no, they didn't, because it wouldn't have been useful in this case.
You also didn't see any photos of Danny Green's position in the vehicle during the accident?
No, I don't recall seeing them.
and I'd like to talk about injuries in today's case. Now, in direct examination, you testified Rob Dillard had a subarachnoid hemorrhage.
That's right.
This is a bleed in the brain.
More or less.
It was caused by a collision of Rob Dillard's skull and another object.
That's right.
But, doctor, you don't know what Rob Dillard's skull collided with.
No, it's not really possible to figure out exactly when that could have happened during the collision.
That's right, you don't even know when during the course of the accident this injury occurred.
That specific injury, no.
Now, Rob Dillard also suffered from a lacerated aorta.
That's right.
And you define this as an acceleration-deceleration injury.
Yeah, that's right.
Now, you believe it occurred when the car hit the pole.
That is the most likely moment where it could have happened.
And to be clear, an acceleration-deceleration injury happens when a body in motion comes to an abrupt stop.
When a body in motion comes to an abrupt stop or a change in direction, which is what happened in this case.
Doctor, just to be clear, when the car hit the pole, it began to spin.
That's right.
I'd also like to talk about Danny Green's injuries. He sustained fractured ribs on the right side.
That is correct, yeah. As it was a passenger-sided collision, both occupants had a lot of injuries on the right
He
side.
specifically had a collapsed lung on the right side,
That's right.
bruised kidney on the right side,
That is correct.
and of course we can agree that the passenger seat is on the right side of the car.
That's right, and it was a passenger-sided collision, which is why both Mr. Dillard and Mr. Green had passenger-sided collisions, right-sided collisions, but Mr. Dillard's injuries were far more severe, which was a big part of my conclusion.
You believe Rob Dillard was the passenger at the time of the accident.
That's right.
And I want to talk about where you got this idea. It's true that prior to completing your autopsy, you spoke to Detective Misty Knight.
That was, yeah, that's
Who
right.
told you Rob Dillard was the passenger at the time of the accident.
Yeah, so before I conducted my autopsy, I was informed that the police had concluded that
Dr.
Mr. Dillard
Hopkins,
was the
that
passenger
was
at the
the
time of the
conclusion
accident.
the police had come to.
Yes, it wasn't the conclusion that I had come to, and ultimately it doesn't really affect the way that I do an autopsy, as an autopsy is really just fact.
Dr. Hopkins, you didn't ask the police how they had come to this conclusion.
No, I didn't, because I ultimately came to my own conclusion, and I didn't consider the police's conclusion when coming to my conclusion.
But it's true. You were told Rob Dillard was the passenger, and then you completed your autopsy.
That's right.
And you came to the same conclusion as the one you were told.
Yeah, ultimately the facts lined up with Mr. Dillard being the passenger in the collision.
No further questions, thank you.
Thank you. Redirect.
Yes, Your Honor. Now, Dr. Hopkins, on cross-examination just then, you were asked questions about why you didn't collect forensic evidence at the scene. Could you now explain why that wouldn't have mattered?
Yeah, so forensic evidence in this case, specifically DNA evidence from inside the vehicle, it really wouldn't have been useful for three main reasons. First, we know it was Mr. Green's car, so we know he had sat in the driver's seat before. We know Mr. Dillard had sat in the passenger seat before, so both of their DNA would have been found in those seats. And on top of that, during the collision, the vehicle was tumbling and both occupants had severe lacerations. There was blood flying everywhere, so any DNA evidence, it really wouldn't have been relevant to the position of the occupants in the vehicle.
Thank you, Doctor. You were also asked questions about the relative injuries of Danny Green and Rob Dillard. Who suffered a lacerated aorta during this collision?
Only Mr. Dillard.
Who suffered a subarachnoid hemorrhage?
Only Mr. Dillard.
Who died of their injuries?
Again, just Mr. Dillard.
And what side of the vehicle was the brunt of the collision on?
The passenger side where Mr. Dillard was sitting.
Thank you. No further questions, Your Honor.
You cross?
No, Your Honor.
Thank you. You may sit down. Give us just a reset. Plaintiff, you may call your third witness.
This time, the plaintiff calls EMT Charlie Schrader to the stand.
All right? Charlie Schrader.
Good afternoon, Mr. Schrader. Could you please introduce yourself to the jury?
Afternoon. I'm Charlie Schrader, and I live here in Miltonville.
Did you grow up in Miltonville, Mr. Schrader?
No, actually, I'm from Pennsylvania. I moved here about 10 years ago.
What brought you down to Georgia?
Well, a couple things. I'm a firefighter, and the pay here is a lot better. Also, I do not miss those Pennsylvania winters with all that snow, and I mean, them Southern girls, the way they talk.
Mr. Schrader, you mentioned you're a firefighter. With which fire department do you work at?
I'm with the Miltonville Fire Department.
And how did you become a firefighter?
Well, back in Pennsylvania, I went through a community college training program, completed practical and theoretical examinations and tests, and I become a certified firefighter and emergency medical technician.
What's your typical work schedule like at the Millville Fire Department?
Well, these days we usually work 24, 48 shifts. That's a full day on duty and 2 full days off duty. It might sound like a lot, but it's honestly pretty normal practice for most firefighters. We use those off days to basically stay in shape, get good rest, and after 15 years of having done it, it's really become a second nature to me, and I am great at staying alert and maintaining focus even during those late night shifts.
Let's talk about one of those late night shifts. What were you doing on the early morning hours of August 1st, 2021?
That morning, I was nearing the end of my shift, finishing up at the fire station.
What happened at 2 a.m.?
2 a.m. we got a operator dispatched a call on a 1050 needing a 1052 for a 53. Or I'm sorry, those are first responder codes. Basically, a 1050 means there's a car accident. 1052 means they need an ambulance, and a 53 means there's a person injured. So I figured from the codes it sounded like a pretty rough crash.
Where was this car accident that you were called to?
It was at 1731 North Athens Street.
What was the first thing you saw upon arriving on scene?
Well, the first thing I saw when I got there was a Ford sedan at the bottom of a hill. It had been pretty badly damaged. I also saw a telephone pole, one of the wooden ones. It was kind of splintered and leaning over to the side a little bit off the side of the roadway.
Did you go down to the sedan?
Of course I did. My job's to save lives. I ran down there as fast as I could.
What did you find upon arrival at the call?
Well, there was, obviously, the first thing I noticed was a unconscious man in the driver's seat, slumped over the steering wheel. So, of course, checked his pulse. Thankfully, he had one. So, me and my partner, Natalie Barker, together we got him out of the car, onto the stretcher to send him to the hospital.
Was he unconscious the entire time on the stretcher?
No, actually, he did begin to stir while we were putting him on the stretcher.
What did he say as he stirred?
He said, "I can't believe I let this happen."
Objection, Your Honor, pursuant to Rule 801 and 403, may I be heard?
You may.
This statement is inadmissible under Rule 801. This is hearsay being used to prove the truth of the matter asserted. Additionally, this statement is more prejudicial than it is probative. The ambiguity of such statement would only prove to mislead the jury or confuse the material issues of this case as to who was driving that night.
Response.
As to the hearsay objection under 801, under 803.2, this is an excited utterance that's made about the conditions of the crash. Furthermore, pursuant to 804.A5, the declarant of the statement is, pursuant to stipulation 25, considered unavailable, and therefore under 804.B3, the statement that he made, "I cannot believe I let this happen," would not have been made if it weren't true, as it would expose him to criminal liability. As to the 403 objection, the main issue in this case is that, one of the main issues in this case at least, is that whether Danny Green or Rob Doe was driving. This helps to establish that for the jury, and the probative value of it is not substantially outweighed by the danger of unfair prejudice.
Your Honor, if I may?
Yes.
This statement is not an excited utterance because Danny Green has not only mumbled this statement, but he is intoxicated beyond the legal limit. Furthermore, he is not stating the conditions of the crash, the circumstances he's in. He's not making any clear statement towards his surroundings, and the jury cannot ascertain who it is he intended this statement for or what he intended this statement to mean.
All right. I'm going to overrule. I will hold that goes to the weight the jury should give the statement, if any. I'll admit it under an excited utterance exception.
Yes, Your Honor.
Mr. Strader, could you please repeat what Danny Green told you?
He said, "I can't believe I let this happen."
Were there any other victims on scene?
Yes, actually. When I administered the driver, I noticed a man lying on the ground about 30 feet from the car.
Did you go over to him?
I did. I ran over and I checked his pulse, but he did not have one. He had passed away.
Could you recognize this man?
I could. It was Rob Doe.
How do you know Rob?
Well, him and his brother Jordan, their parents, they had that billiards place back in Miltonville a few years back, and I remember when I first came to Miltonville, that was one of my favorite places, I mean, I sort of got to watch the two of them grow up. It seems like just yesterday. tearing around the billiard shop, swiping sodas from their parents' bar. And so, yeah, I did know him a little bit.
At some point after arriving, did the police ever arrive on scene?
They did, about 10 minutes after I did.
How did you assist their investigation?
Well, Officer Daystrom was the officer in charge, and so I helped him out. I gave him information to fill out his accident report, also doing the sketch of the scene.
Would you recognize the sketch if I showed it to you?
Probably.
Let the record reflect that I'm approaching opposing counsel with Exhibit 1. Oh, there goes the other one.
Exhibit 1, if I may, in the photograph.
I'm approaching opposing counsel with Exhibit 1. Approaching Mr. Schrader with Exhibit 1. Mr. Schrader, do you recognize what is depicted in this exhibit?
Sure do.
What is it?
It's the sketch I made of the scene.
When did you make the sketch?
Around the end of my shift, early that morning.
The plaintiff offers Exhibit 1 into evidence, the authenticity and accuracy of which have been stipulated pursuant to Stipulation 9.
Response.
No objection, Your Honor.
Submit without objection.
May Mr. Schrader step down for demonstrative purposes?
He may and you may reposition.
If you could bring the exhibit with you, please, Mr. Schrader. Hold it, please. Mr. Schrader, could you explain what this here circle is?
That circle is the telephone pole that the car by the side of the road.
And what is the square?
That is where the vehicle was, the Ford sedan at the bottom of the hill.
What position was this Ford sedan in?
It was upright on all four wheels.
If you could please describe the damage that the Ford sedan had taken for the jury, please.
I could. The driver's side, where I found the man unconscious, it was pretty badly damaged. The side was kind of dented and crushed in a bit. The airbag had deployed on the driver's side. The roof and the hood of the car also both very badly dented and crushed. The passenger side clearly gotten the worst of the damage. It was completely impounded. The foot end, it was crushed. There was glass everywhere. The window and the windshield had shattered. It was the passenger side. I would not have been one to sit in that seat when the crash happened.
Who is this stick man right here?
That's where I found Rob Dillard.
You must sit down. Mr. Schrader, let's go back to the car itself. I'm showing you Exhibit 2, which has been previously tendered. Do you recognize the man depicted in this photograph?
I do.
And how do you recognize this man?
He was in the driver's seat of the car,
What position was he in the driver's seat?
slumped over the steering wheel, unconscious.
And what is his name?
Danny Green.
No further questions, Your Honor.
Thank you. Cross-examine.
May I inquire how much time defense has left?
Time check.
6 minutes and 44 seconds.
The part of the timekeeper's in agreement with that?
Yes, Your Honor.
All right, very well.
May I proceed?
You may.
Hello, MT Schrader. On direct examination, you said you heard Danny Green say, "I can't believe I let this happen."
That's right.
But it's true you don't know what he meant by this statement?
I don't know what he was talking about.
No, he could have meant, "I can't believe I let myself drink so much."
He could have meant any number of things.
He could have meant, "I can't believe I let Robert drive."
I can't tell you what he meant. I wasn't there.
Well, let's talk about what else you don't know about this accident. You don't know how close the driver's seat was to the steering wheel, do you?
No.
No, you don't know because it's not your job as an emergency medical technician to take pictures of the scene, is it?
That's right. I'm a firefighter, not a detective.
You didn't take any pictures of the scene.
I did not.
Let's talk about what you saw on the scene. You saw broken glass everywhere.
I did.
You saw the driver's side airbag deployed in the wrecked car.
That's right.
And you saw the lamppost that the car hit.
The telephone pole, you mean?
This would be separate from the lamppost you say assisted your vision that night?
Yes.
And it's true that this lamppost is not indicated in the sketch that you rendered?
That's right.
And so it's not available for the jury to see where this lamp that assisted your vision is because it's not included.
Well, right, but I didn't include it. I mean, it was still there when the police arrived after I did, so I didn't feel it was necessary to include in my sketch.
Let's talk about what else you saw. You saw a passenger farther away and on his side.
Rob Dillard.
Once you recognized him, you began CPR.
I did.
And so let's talk about what you did to keep Robert Dillard alive. When you are doing CPR, you're pumping the person's heart for them, weren't you?
Well, yes, that's true, but I did attempt CPR, but I determined he'd already passed away.
You attempt CPR on someone who doesn't have a pulse, correct?
That's what I did.
And Robert Dillard did not have a pulse.
Correct.
And you are aware that CPR should be performed until the victim can reach the hospital.
Yes.
Yet you didn't wait for a second ambulance to arrive before you halted CPR on Robert Dillard.
No, he was already passed away.
You halted CPR on Robert Dillard to check his wallet.
Yes.
And you did not ask your partner, EMT Natalie, to take over for you?
No, I mean, again, it was sad, but I had determined he'd already passed away.
EMT Schrader, it's not your job to declare death either, is it?
No.
No, your job as an emergency medical technician is to perform life-saving measures such as CPR.
Yes, but I do have 15 years experience, and
EMT Schrader, was confirming Robert Dillard's name more important than breathing for him and pumping his blood?
Objection, Your Honor. Pursuant to Rule 401, this line of testimony that's been thoroughly explored is not relevant to this case at all. The negligence of Mr. Schrader, the possible negligence of Mr. Schrader is not at issue here. The only negligence at issue is Ms. Casey Farnsworth.
Response.
Pursuant to Rule 401, relevant evidence is any evidence that would make a fact of the case more or less likely, and the injuries that Robert Dillard received that night are being called into question in order to understand who was driving the car that night. Therefore, the CPR that EMT Schrader performed on Robert Dillard is relevant. And furthermore, pursuant to Rule 611B, I'm doing a thorough and sifting cross-examination, and Attorney Matisse has opened the door to the CPR on Robert Dillard on direct examination.
How do you contend that the CPR will assist the jury in understanding who was driving the car?
Because the injuries that Robert Dillard received are used as proof to which seat he was sitting in, the driver's seat, but if there are other possibilities as to how he retained those injuries, the jury has a right to know that.
All right, very well. Response.
Your Honor, I would then raise the objection of 403, the balancing test. This would confuse the issues. Like I said, the negligence, the determination of negligence is solely on Ms. Farnsworth, not Mr. Schrader. Well, Mr. Schrader did and what he tried to do is not relevant, and the probative value is substantially weighed.
If I understand correctly, you are not trying to contend that Mr. Schrader was negligent in any way, are you?
Absolutely not.
You're simply to show a potential source of injuries, is that correct?
Yes, Your Honor.
All right, for that limited purpose, I'll overrule.
Yes, Your Honor. EMT Schrader, was confirming Robert Dillard's name more important than breathing for him?
Objection, Your Honor. Pursuant to Rule 43A, this is an argumentative question.
Response.
I can rephrase the question if opposing counsel would like.
I'll allow a little leeway. It was borderline argumentative, but a little bit of that is allowed on cross. Just be careful not to cross line. I'll
Yes, Your
overrule.
Honor.
Yes, Your Honor. EMT Schrader, I'll ask you one more time. Was confirming Robert Dillard's name more important than breathing for him?
It was not, but I did determine that CPR was not. He was gone.
Thank you, Your Honor. No further questions.
All right, any redirect?
Yes, Your Honor. Mr. Schrader, you're an EMT, correct?
Correct.
Is your job to take pictures of the accident scene?
No.
And finally, Mr. Schrader, could you please explain to the jury one last time why you did not continue CPR on Mr. Rob Dillard?
I'd finished with CPR because I checked his pulse. He didn't have one, which is then why I started CPR, but after multiple minutes of CPR, he was still not breathing, and 15 years of experience, that means that they're gone.
No
Again,
further questions.
my condolences to Mr. Dillard.
Any recross?
Yes, Your Honor. EMT Schrader, your job as an emergency medical technician is to perform life-saving measures, correct?
That's right.
You would consider CPR a life-saving measure?
When it works, that's correct.
And Robert Dillard had no pulse when you received him?
Right, that's why I started CPR.
Thank you. No further questions.
All right, witness may step down. Does the plaintiff have any additional evidence to present at this time?
The plaintiff rests, Your Honor.
All right. Give us just a brief second to catch up on our notes, and then we'll proceed with the defense case in chief. prepared to call your first witness?
Yes, Your Honor. At this time, the defense calls Ms. Casey Farnsworth to the stand.
Ms. Farnsworth, if you'll step to the witness stand, please.
May I proceed?
You may.
Hello, Ms. Farnsworth.
Hello.
Please introduce yourself to the jury.
Good afternoon. My name is Casey Farnsworth, and I'm the proud owner of the Miltonville Mini Market.
How did you become the owner of the Miltonville Mini Market?
I came into a little bit of money from my family, and I had been thinking about some ways to get more involved in my community. And so I bought what was once a dingy old store in Jenkinstown, and I fixed it up and made it my own.
When was it you bought this property?
2016.
And how would you describe the Miltonville Mini Market?
Well, I think it has all the magic of a Buc-ee's, but with some small town charm and friendly faces.
Is the Miltonville Mini Market involved in the community?
Absolutely.
Objection, Your Honor. This line of questioning that I assume the lawyer will attempt to go down is not relevant to this case. As far as its involvement in the local community will not help determine liability here today.
Now,
Response.
Ms. Farnsworth is here today because she sold alcohol to an underage person, and therefore, if I may proffer, she is going to explain how she's involved in her community on behalf of underprivileged underage people, which is relevant in understanding how she would interact with other underage people.
Response.
Your Honor, I stand by my objection. Her involvement in the local community does not have anything to do with why we're here today.
Close. I'm going to overrule, to, if nothing else, to give a little bit of background about her business. But if you believe she goes in too much detail on that, you may renew your objection.
Of course, Your Honor.
Yes, Your Honor.
All right.
Ms. Farnsworth, is the Miltonville Mini Market involved in the community?
Absolutely. We are a member of the Safe Haven
Objection, Your
program.
Honor. I'll move to strike this testimony pursuant to Rule 611E. By going into Safe Haven program, I believe you went where they asked, went too far on this. The Safe Haven program, the fact that she's involved in that is solely to bolster her witness testimony and is not helpful for determining liability here today.
Response.
I would attest that Ms. Farnsworth's actions on behalf of underage, underprivileged people are relevant in today's case. And I have only asked one question since the objection was raised.
I want to sustain the objection.
Yes, Your Honor. Ms. Farnsworth, I want to address why this complaint has been filed against you today. How did you know Mr. Green?
He was one of the regulars at my store
And how long had he been coming into your store?
since the summer of 2020.
What do you usually buy?
On the weekdays, he would buy some snacks, some of our world-famous roller dogs, and on the weekends, he would buy a six-pack of the Dogstar Tall Boy beers. It's a very popular choice.
Do you remember asking for his ID during this time?
I do not. I have racked my brain about it so many times and thought about it, but I can't pinpoint any specific day, and I would never want to give any of you an incorrect one.
How old did you believe Danny Green was at the time?
I believe that he was at least 25 or maybe even older.
Would you recognize a picture of him if I showed it to you?
Absolutely.
Let the record reflect I am retrieving what has already been entered as Exhibit 2.
All right.
Here you go, Ms. Farnsworth. Now, you recognize Exhibit 2 as a picture of Danny Green, correct?
Yes,
Could you tell the jury why you believe Danny Green was at least 25?
absolutely. So as you can see from the picture, he has some crow's feet around his eyes. He also has a very strong, defined, angular jawline and a distinct 5 o'clock shadow.
Thank you, Ms. Farnsworth. Now, were there any other indications to you that Mr. Green was over the age of 21?
Yes, since the time he had started coming into my store, he had always been very, very polite, very respectful, and overall seemed very mature.
Well, now let's talk about July 31st. What were you doing that day?
Although I am the store's owner, I often work behind the counter, and that's what I was doing that day.
And how many times did Mr. Green come in?
He came in twice.
Tell us about the first time.
The first time he came in was around 1:30 in the afternoon. He came in with a man I later learned was Mr. Dillard. He picked up a six-pack of the Dog Star Tallboy Ales and checked out.
Did Robert Dillard buy anything?
No,
And did you see how the young men left your store?
I did not. I cannot see anything from its place at the register.
Well, tell us about the second time that Mr. Green came in on July 31st.
He came in around 7 in the evening, this time alone, and he picked up another 2 packs of the Dog Star Tallboy Ales and checked out.
Did he mention to you what he planned to do that night?
Yes, we had a little chatter while I checked him out, and he told me that he was in for a quiet, relaxing night in with his friends playing cards.
What can you tell us about his demeanor?
He seemed completely normal. There was nothing of note.
Did you ask for his ID?
I did not, because we are a community store and most of my customer base is our regulars. It's not typical of me to ask for a regular's ID every single time that they come in once they're established.
And did you see how Mr. Green left?
I did not.
Well, after July 31st, what happened?
I was approached by the police later in August, and they informed me that Mr. Green had been 20 that night, which was shocking. I wish that I had known about Mr. Green's age. All Mr. Dillard had to do was tell me. If I had known, I never would have made that sale. But I had no warning of what Mr. Green's age was, or that he was going to go to a party that night.
After the police informed you of Mr. Green's age, were there any legal consequences?
Yes, I was issued with a citation, and I had to pay a fine.
Had you ever received a citation like this before?
Objection, Your Honor. Pursuant to Rule 404A, this testimony that Ms. Farnsworth has never received a citation before is solely to prove that Ms. Farnsworth is not liable here again today. Furthermore, pursuant to Rule 403, the danger of misleading the jury substantially outweighs its probative value, as the fact that Ms. Farnsworth has never been caught selling alcohol to a minor before has absolutely no probative value, and therefore would substantially confuse the jury more than it would provide probative value.
Response.
Yes, Your Honor. Casey Farnsworth is, well, pursuant to Rule 403, this is probative evidence because Casey Farnsworth Ms. Farnsworth is selling alcohol. She has been a business owner for 8 years now, and the circumstances under which she runs her business, such as never receiving a citation before, is important for the jury to understand. It will not mislead them, confuse the issues of this case, or cast unjust prejudice.
You may close on your objection.
Your Honor, I stand by the same thing. The statement that Ms. Farnsworth has never been cited before and actually being caught selling alcohol to minors has very little probative value, and what scant probative value does have is substantially outweighed by the danger of unfair prejudice and misleading the jury.
Sustain the objection.
Yes,
Yes, Your
Honor.
Honor. Ms. Farnsworth, well, I want to talk about what you do to prevent underage vending in your store. What do you do to deter underage people from buying alcohol?
I have a sign up in my store that says under 30 VID. This serves as a deterrent, and it puts my customers on notice.
Where is this sign visible?
It's by my register.
And if you don't ask for identification for everyone who's under 30, what is your policy on selling alcohol?
My policy is that if someone comes in and they do not clearly look over the age of 21, they will be ID'd.
Have you ever made any exceptions to this policy?
Never.
And has this policy been successful for you until now?
It had until the
Objection,
issue.
Your Honor. For the same reasons as previous, this probative value of this is substantially outweighed by the danger of unfair prejudice. The fact that Ms. Farnsworth has never been caught selling alcohol to a minor, by saying that her policy has worked in the past and she's never been actually caught for selling alcohol to a minor, has no probative value.
Response.
Casey Farnsworth is here to testify today under the conditions in which she sells alcohol in her store. Her policy on selling alcohol is not more prejudicial than it is probative. It is information that the jury should know as to how she runs her business.
If I may, Your Honor, I believe the question wasn't about the specific policy, it's whether this policy has worked. Whether this policy has worked, whether Ms. Farnsworth has been caught for selling alcohol to minors before in the past, has no probative value, substantially outweighed by the danger of unfair prejudice as previously ruled.
Again, I'll sustain.
Yes, Your Honor. No further questions.
Thank you.
May I proceed?
You may.
Good morning, Ms. Farnsworth. Or good afternoon, Ms. Farnsworth. My name is Connor Mattias. A few questions for you today. You understand as a reasonable and prudent store owner, you must be reasonable and prudent when determining whether to ID someone, correct?
Of course, and I always am.
And as a reasonable and prudent store owner, you have cameras in your store, don't you?
I actually do not. I did at one point, but at the time of the incident, I didn't. I'm not legally required to have them.
Ms. Farnsworth, there is in fact cameras in your store, but they are broken, aren't they?
Yes.
Or they were broken, I'm sorry.
Yes, they were at the time of the incident, if that's what you're referring to.
Yes, and about 2 years prior, they were also broken, correct?
2 years prior to what exactly?
To July 31st, 2021, the day of the incident.
Yes,
And over that 2-year period, you did not fix your cameras, did you?
I did not. I'm not legally required to have cameras in my store, and I hadn't gotten around to it. My store keeps me very busy.
Ms. Farnsworth, let's talk about some of your first interactions with Danny Green. When Danny first started coming into the store, he would come with his friend Steven, correct?
Yes,
And Steven would buy alcohol, wouldn't he?
yes,
And you would sell alcohol to Steven.
of course. I ID'd him, obviously.
And since you ID'd him, you found out he was over 21. That's why you sold it to him, correct?
Yes,
But Danny wouldn't buy alcohol, would you? Did he?
at that time.
I'm sorry, he would not buy alcohol with Steven, did he?
No, he did not.
It wasn't until a few weeks later when he started coming in by himself to buy alcohol, did he?
Oh, the timeline is not clear. There was just a period of time that passed before Mr. Green had begun buying alcohol.
Okay, and when he started buying alcohol, he wouldn't be with Steven, would he?
No, he would come in alone.
He was nice to you.
He was respectful.
Yeah, and he never tried to steal from you, would he?
No, which is something that most teenagers do when they are attempting to buy alcohol underage.
Exactly. So because Mr. Dillard was respectful and nice, you just said that this is the quality of an underage person, correct?
Because Mr. Dillard?
Mr. Dillard, like you just said, was respectful and nice, and you just said this is the quality of an underage person.
Oh my goodness, I've made a mistake. I thought that you were referring to Mr. Green.
No, Mr. Dillard.
I can't really speak to Mr. Dillard's character because I didn't know him well. I can say that I did get kind of a bad energy from him, but I can't speak to anything specifically that he ever did.
Sorry, let's talk about Mr. Green. Mr. Green was nice, respectful, correct?
Yes, Mr. Green was.
And so you sold alcohol to him, correct?
No, I sold alcohol to Mr. Green because I believe that he was over the age of 21.
Let's talk about July 31st, 2021. When Green first came in your store, it was around 1:30,
Yes,
and he bought a 6-pack of cold beer.
yes,
He came back in around 7 in the evening,
that's correct.
and this time he got 2 6-packs of cold beer, didn't he?
Yes,
He put it on the counter,
that's correct.
and he sold it to you, didn't
Yes,
he? Mr. Green was not carrying a beer cooler with him, was he?
no, he was not.
You don't recall seeing him with a beer cooler with ice that you would put cold beer in to keep cold, do you?
No, I do not.
And when you checked Mr. Green out, you talked to him, correct?
Yes, he told me that he was in for a quiet, relaxing night in with his friends.
You'd agree with me that alcohol somewhat relaxes you, doesn't it?
I mean, maybe. I'm not a big drinker myself.
Ms. Farnsworth, Mr. Green told you he was going to go relax and have fun with his friends that very same evening, correct?
Yes, he was in for a quiet night.
And he told you he was excited to do this, didn't he?
Yes,
And Ms. Farnsworth, you have a sign up in your store saying we will card you if you look under 30, correct?
yes. Like I said, it serves as a deterrent.
And these signs are all around your store, aren't they?
Yes,
Ms. Farnsworth, I'm showing you Exhibit 8. This is that sign that you were just talking about, correct?
that's correct.
looking at Danny Green here, on direct testimony, you said that Mr. Green has, what do you call these? Crab legs?
Crow's feet.
Crow's feet? Ms. Farnsworth, if you look at me, I'm 16 years old. Do you notice my crow's feet?
I do not.
Ms. Farnsworth, are you saying that Danny Green's crow's feet are more substantial than the ones on my face right here?
Yes, I would say that.
Mr. Farnsworth, or I'm sorry, Ms. Farnsworth. Ms. Farnsworth, Danny Green does not look 30, does he?
No, he does not, but he does look over the age of 21.
He does not look 30, does he?
No, he looks over the age of 21.
Ms. Farnsworth, despite Danny Green not looking 30, you did not ID him on the day in question, did you?
No, I followed my policy.
Ms. Farnsworth, you'd agree with me that if you had followed that sign in your store, you would have ID'd Danny Green, wouldn't you have?
To be clear, the sign in my store is not my policy. My policy is that if someone does not clearly look over the age of 21, they will be ID'd. The sign in my store is just a deterrent.
Ms. Farnsworth, I'm clear with that, but you would agree with me that if you had followed the sign in your store, you would have ID'd Danny Green.
I would have, but it's not my policy.
And if you had ID'd Danny Green, you wouldn't have sold him the alcohol, would you have?
Of course not. I would never sell alcohol to an underage person.
Ms. Farnsworth, all you had to do was ask.
And I'm not saying that I never did. What I'm saying is that I cannot pinpoint any specific day, and I would never want to give an incorrect date.
You were here when the deposition testimony was read, correct?
That's correct.
And you heard Danny Green say that he doesn't recall being ID'd.
No.
And you don't recall specifically IDing Danny Green ever, did you?
No, neither one of us recall any specific day.
Furthermore, Ms. Farnsworth, I understand that your store sells gas. You've seen Danny Green buy gas in the past, correct?
Yes.
In fact, you've seen him drive up in a car.
On a few occasions, I did see him drive to my store.
And you've seen this enough times to know that it was a red car, correct?
Yes,
And you thought this was likely American make.
I believe so.
Ms. Farnsworth, in fact, you've seen him buy alcohol on a few of the same occasions in which he drove up in this red, maybe American-made car, correct?
No. Like I said, he bought a variety of things from my store. He would come in and buy gas, or roller dogs, or on the weekends, beer.
Ms. Farnsworth, this is your testimony here today. You've never seen Danny Green buy alcohol on some of the same occasions in which he drove up in that red, maybe American-made car.
Yes, on a few occasions he did drive into my store, but not on any specific occasion that I can remember when he was purchasing beer.
Ms. Farnsworth, you made a statement, correct?
Yes,
And I'm approaching opposing counsel with Ms. Farnsworth's statement. 57. Ms. Farnsworth, you verified this morning that that statement was true and correct.
yes,
And you signed here at the bottom, right?
I did.
And you'd agree with me that this is your statement.
Yes,
And you didn't have any things substantial to add to your statement, did you?
I did not.
Ms. Farnsworth, I'm going to read lines 53 through 57. But on most weekends, he'd swing by and purchase a six-pack or two of his favorite beer, Millenville City Brewery's Dog Star Ale. It's a local hit. Skipping ahead, on a few of those occasions, I did see him drive up and leave in a small red car. Ms. Farnsworth, there have in fact been occasions in which you've seen him buy alcohol while driving his red small car.
Yes, but not on that night.
No further questions, Your Honor.
Redirect.
Yes, Your Honor. Ms. Farnsworth, why is it that you didn't ask Mr. Green for his identification on July 31st?
I believed that he was 25 or older.
And on July 31st, did you see how he left your store?
No, I did not.
Thank you. No further questions.
All right, thank you. Any recross?
No, Your Honor.
Thank you. The witness may step down. You may call your next witness.
At this time, the defense calls Simone Bella.
All right, Ms. Bella, you'll come to the witness stand, please. You've been sworn.
Ms. Bella, before we begin, I want to make sure the jury can hear you. Can you move the microphone a little bit closer?
Yes, I can. Is that okay?
All right. Permission to proceed, Your Honor?
You may.
Good afternoon, Ms. Bello. Please introduce yourself to the court.
Good afternoon. My name is Simone Bello, and I'm 56 years young.
What do you do for a living, Ms. Bello?
Currently, I'm a public information officer at the Department of Budgeting and Revenue, which basically means I turn numbers into little tidbits journalists can put in their stories. That's actually where I started my career in journalism. I got my degree in journalism.
And do you live alone, Ms. Bello?
Now I do, but I used to live with my dog, Rags Bello. He was Aces. I am, however, on silver singles now, waiting for someone to swipe right.
Silver singles. Wow, you don't look a day over 17.
Thank you, that's very flattering.
What's your address, Ms. Bello?
I live at 1731 North Athens Street here in the lovely town of Miltonville.
And is there anything notable about your house?
Well, a keen eye like mine would notice that the gutters could use some cleaning, but the other notable thing would be the location.
Why is the location of your house notable?
Well, my house sits on North Athens Street, which is a curved road. My house sits below the curve on a downward slope. I'm actually in between Miltonville High School and my alma mater, Miltonville State University. So kids are always coming whizzing by. I've been worried that one would miss that curve and hit my house or go into my yard.
And has one of those kids ever missed the curve and gone into your yard or your house?
Unfortunately, on the early morning of August 1st, one did.
We're going to go back to the morning of August 1st in just a second, but first I want to go back to the night of July 31st. Could you tell us what you were doing that night?
Yes, the last Saturday of every month I have a monthly poker night with some of my old friends. I bring 3 things: my lucky socks, a growler of my favorite IPA, and of course my spicy dill pickle potato chips.
You said that you bring a growler of your favorite IPA. Could you explain for the court what that means?
Yes, IPA is India Pale Ale. It's a kind of beer, and a growler is a jug of beer. It's less beer than is in a 6-pack.
And did you have any of the beer you brought in your growler on July 31st?
Yes, I drank about half my growler, which is about 3 or 4 cups of beer. Obviously, I didn't drink my whole growler. I had a poker game to win.
And how did you get home the night of July 31st?
I Livered. It's one of those overpriced rideshare apps. Whenever we have poker night at someone else's house and I know I'm going to be drinking, I Livered there and back, whether I've had 1 or 10 beers.
And what time did you get home?
It was around 11:20.
So what did you do after getting home at 11:20 after poker night?
Well, when I got home, I took my dog Rags on a short walk. I will say it was a bit rushed. I was very excited to catch Saturday Night Live.
And what time did you get to sleep that night?
It was around midnight.
Did you sleep through the entire night, Miss Bella?
No, unfortunately I did not. I was woken up around 2 a.m. by my dog Rags.
How do you know that it was 2 a.m. when your dog Rags woke you up?
Well, I woke up and he was in my face. I remember looking over at my alarm clock and it said 2:07 a.m. And I realized he hadn't gone number 2 on his walk earlier and needed to go then.
So what do you do after waking up at 2:07 in the morning and realizing that your dog Rags needs to be taken out?
I was pretty motivated to take him out quickly, so I threw on a coat and I took him outside. Rags was taking care of business, and I remembered to tip my Liver driver. And as I was doing that, the next thing that happened, I really had no knowledge, no warning of what happened next.
What happened next, Miss Bella?
I hear tires screeching. I look up and a car is ramming into the pole in front of my house.
What happens after you see a car ram into the pole in front of your house?
It bounces off the pole, does a 180 turn, and it flips, and it flips, and it flips. And luckily it didn't hit me or my house, but the people inside the car weren't so lucky.
What do you mean the people inside the car weren't so lucky?
I saw someone fly out of the driver's side during all of these flips.
Do you know who flew out of the driver's side, Miss Bella?
At the time I didn't know who it was, but I now know it was Rob Dillard.
So what do you do after seeing Rob Dillard fly out of the driver's side?
I'm no EMT like the man in the blue suit over there, Mr. Schrader, but I thought that Rob Dillard was already gone. So nevertheless, I called 911 and they were there within 5 minutes.
What happened after the first responders arrived on the scene?
In all of the chaos, I had let go of my dog Rag's leash. As Kenny Rogers says, you're supposed to know when to fold them and when to hold them. I didn't hold Rag's leash and he was hit by a vehicle and killed. All I had to do was hold his leash.
I have a few final questions for you about the night of the accident. Do you know any of the Dillers?
No, I do not. I mean, it's a small town, but I don't personally know any of them.
Do you know Casey Farnsworth?
No, not until I saw her today in court.
What, Miss Bello, do you remember the most about seeing the accident on August 1st?
Apart from holding the body of my sweet baby Rags, it was seeing that young man fly to the driver's side of the car.
Thank you, Miss Bello. No further questions at this time, Your Honor.
All right, thank you. Cross.
Yes, Your Honor. Ms. Bell, I'm just going to ask you a couple questions about that night. So before the crash, you were at a party, correct?
Yes, at my poker night.
Right, you were at your poker night and you had a couple beers to drink, didn't you?
Yes, it was half my growler.
And that's equivalent to around 3 or 4 beers?
Yes, that is correct.
And that poker game lasted until around 11 o'clock, correct?
Yes, and I got home around 11:20.
You got home around 11:20, but then you were woken up at 2:07 a.m., weren't you?
Yes, that is correct.
Now, given how little sleep that was, you felt that you were half asleep, didn't you?
Yes, when I first woke up, I did feel half asleep.
Now, let's move on to the crash itself. It happened really fast, didn't it?
Yes, it did, but when something traumatic like that happens, it almost feels like it's in slow motion.
Right, the car overcorrected on the curve, correct?
Yes, it did a 180 turn.
And then it proceeded to collide with the telephone pole.
Yes, it did.
And the point of impact of that collision was the front passenger side, right?
Yes.
And that collision was hard, wasn't it?
I don't know exactly how hard it was, but I would assume so.
Well, you describe in your own statement that it was hard, don't you?
Yes, I mean, I wasn't in the vehicle, though.
Okay, and so after the car hit the pole, it proceeded to tumble down the hill, right?
Yes, it did, and that's when I saw Rob Dillard fly to the driver's side.
Right, it tumbled down like a front-loading clothes dryer, correct?
Yes, that is correct.
And you say you saw Rob Dillard ejected, but during that whole thing, you were slightly buzzed, weren't you?
Yes, I was slightly buzzed.
That meant that you were still feeling the effect of the alcohol you had had earlier, right?
Yes, I was. However, I do know what I saw.
And that night, you had Libert home, didn't you?
Yes, I did.
You were tipping that Libert driver right before the crash happened, in fact, correct?
Yes, that is correct, and I was slightly blinded, but I did still see what happened.
Right, you were slightly blinded because when the crash happened, you looked up from your bright phone to your dark yard, and that disparity in light slightly blinded you, didn't it?
Slightly, yes.
Okay, so let me get this straight. From what you could perceive of that crash, it was pretty chaotic, wasn't it?
Yes, it was.
So while you were viewing this fast and chaotic crash, you were half asleep.
I was half asleep when I first woke up, but an event like that really wakes you up.
While you were perceiving this fast and chaotic crash, you were slightly buzzed.
Yes, I was slightly buzzed.
And while you were perceiving this fast and chaotic crash, you were somewhat blinded.
Yes, I was, and I know what I saw, and I'm quite confident about what I saw.
Well, because of all those things I just listed, you cannot be 100% certain today whether you saw the driver or passenger ejected, can you?
No, not 100% certain. Let's say if it was a poker game, I would go all in, but I'm not 100% certain.
So that's a yes to my question. You're not 100% certain.
I'm not 100% certain if it was the driver or the occupant, but I know they came out of the driver's side.
Okay, thank you. So let's move on to after the crash. Naturally, when you see a kid on the floor, you go to check on them, right?
Yes, that is correct.
And then after you called 911, you never went to go check on the vehicle, did you?
No, I didn't. I mean, someone had flown out of the car and into my yard.
Right, you assumed that the person who had flown out was the only person involved in the crash, didn't you?
I mean, I was trying to help the person who I thought was no longer alive.
Well, I mean, I understand that, Miss Bello, but if you had known about another person in the vehicle, certainly you would have checked on them, wouldn't you?
Yes, if I had known, but I didn't.
Right, you only knew there was one person involved in the crash, so you assumed he was the driver.
That is not correct. I didn't assume if they were the driver or the occupant. I just knew that they flew out of the driver's side.
Well, when you only know there's one occupant, they have to be the driver, don't they?
Yes, in theory, but I did not say that they were the driver. I just said that Rob Dillard came out of the driver's side.
Miss Bello, there were 2 people involved in this collision, right?
Yes, I know that now.
And you just testified that you only knew about one when you saw the crash, didn't you?
When I first saw him fly out, yes, I only have seen the one.
No further questions, Your Honor.
All right, thank you. Redirect.
May I ask for a time check?
Yes, there is about 13 minutes and 10 seconds remaining.
On direct, right?
No direct, Your Honor. No redirect.
All right, thank you. All right, you may step down. Hold on just a moment. All right, when you're ready, make arguments with us.
Yes, Your Honor. The defense calls Dr. Tony Friedman.
All right, Dr. Friedman.
Good afternoon, Dr. Friedman. Can you please introduce yourself to the jury?
Good afternoon. My name is Dr. Tony Friedman. I work as a forensic pathologist specializing in accident reconstruction.
And where are you from, Doctor?
I grew up in London town, Cleveland, Ohio.
So how did you become a forensic pathologist?
To become a forensic pathologist, I completed 13 years of schooling. So 4 years to earn my undergraduate degree in biology, another 4 years to earn my medical degree from the Eastern Virginia Medical School, and then another 4 years to complete a residency in anatomical and clinical pathology. Afterwards, I pursued a 1-year fellowship in forensic pathology.
And what exactly does a forensic pathologist do?
Yes, a forensic pathologist uses scientific methods to determine the cause and manner of death.
What experience do you have in forensic pathology?
From 2007 to 2014, I worked for the Georgia Bureau of Investigations, which it's essentially the GBI, but for the FBI, but for Georgia. I worked as a forensic pathologist there.
And what did you do after your time at the Georgia Bureau of Investigation?
After leaving in 2014, I decided to redirect my medical expertise into the field of accident reconstruction.
What is accident reconstruction?
Accident reconstruction is a scientific process using methodology to determine things like injury causation, occupant positioning, and the general dynamics of an accident.
And what experience do you have in accident reconstruction?
Well, during my last 2 years at the GBI, I completed training and attended seminars that would help qualify me as an expert in the field. Additionally, I am certified in accident reconstruction from the Accreditation Commission of Accident and Traffic Reconstruction, or what we pros call ACTAR.
Do you do anything to maintain this certification?
Yes, to maintain the certification, I obtain 80 CEUs every 5 years.
Sorry, what are CEUs, Doctor?
Oh, right. CEUs are continuing education units. So, to meet this requirement, I teach medical examiners at medical conferences about accident reconstruction.
And in addition to teaching, what do you currently do for work?
For the past 9 years, I've been working as a private consultant in the field of accident reconstruction. I've worked in over 600 cases and testified in a courtroom much like this one in over 210 as an expert.
Your Honor, at this time, the defense tenders Dr. Tony Friedman as an expert in forensic pathology and accident reconstruction. No objections, Your Honor.
All right, he's so qualified.
Doctor, how did you become involved in today's case?
I was retained by the defense to analyze the facts and data so as to come to an informed and proper conclusion as to the leading and consequential factors of the accident, as well as who was most likely driving during the accident.
And what facts and data did you rely on to come to your conclusion?
Oh, well, I reviewed quite a bit, and you'll have to bear with me now. I reviewed the deposition and medical records of Daniel Green, the autopsy report of Mr. Rob Dillard, photographs of the scene of the accident, an accident report, relevant articles pertaining to similar circumstanced accidents, the statements of Miss Simone Bello, Mr. Charlie Schrader, and Dr. Hopkins, as well as having the opportunity to review the sketch that Mr. Schrader made and making my own detailed diagram.
Based on all of the evidence you reviewed, what conclusion were you able to come to about who was driving during the accident?
I was able to conclude to a reasonable degree of scientific certainty that Mr. Rob Dillard was the driver of the vehicle.
You mentioned you made your own detailed diagram of the scene. What was the purpose in making this?
Well, after reviewing all of the evidence, I thought it would be helpful to have a more clear understanding of what the orientation of the scene actually looked like.
Would you recognize this diagram if you saw it?
Absolutely.
Your Honor, let the record reflect I'm approaching opposing counsel with what has previously been marked as Exhibit 12.
What?
Exhibit 12. Dr. Friedman, I'm showing you what has been marked as Exhibit 12. What is Exhibit 12?
Exhibit 12 is the diagram of the scene of the accident.
And how do you know Exhibit 12 is the diagram of the accident?
Well, I made Exhibit 12.
And is Exhibit 12 a true and correct copy of your diagram of the accident?
Yes, yes it is.
Your Honor, at this time, the defense tenders Exhibit 12 into evidence.
Any objection to 12?
No objections, Your Honor.
12's admitted.
All right, Doctor, now using your diagram, can you explain to us how the accident happened?
Well, I could, although I'd be far more effective if I could just mosey on down there and explain up close.
Absolutely, Your Honor. Does Dr. Friedman have permission to step down from the
He
witness
does, and
stand?
of course, plaintiff's counsel may reposition as needed.
Yes, Your Honor. And my co-counsel is going to pre-position to hold the diagram.
That's fine.
All right, Dr. Friedman, can you explain what we're looking at here?
Yeah, so the first thing you see is the road, North Athens Street, which Mr. Rob Dillard was driving down. Next you see point K, which represents Mr. Monbello's house. Now, points F through I, as well as E and A, all represent defects or markings in the grass that are consistent with different parts of the vehicle landing on the ground. Now, points D and B both represent skid marks. And point C is that telephone pole you've been hearing about. Lastly, point J is where the vehicle finally came to a rest on all four wheels.
And now, Doctor, can you walk us through the course of the accident?
Yes, I can. So the sequence begins right about here. And from point A, we can tell that the vehicle likely veered off the right side of the road. Then, pursuant to point B, the vehicle then likely overcorrected.
And what happened after this overcorrection?
After overcorrecting, the vehicle then swerved into the telephone pole, making contact with the front passenger side. Now, at this point, the airbag was deployed, but aside from that, the impact with the telephone poles only served to redirect the vehicle's momentum, having it complete 100 or 180-degree turn before coming to stop around point E.
What happens after this 180-degree turn?
Well, with the vehicle's continued momentum, it then began to flip down the hill before finally coming to a stop at point J.
Thank you, Dr. Attorney Siegel. You may return to your seat. So now that we have a better understanding of how the accident happened, I'd like to talk about injuries. What injuries did Rob Dillard sustain?
Mr. Rob Dillard, his primary cause of death was his lacerated aorta, but he also suffered other injuries such as chest contusions, fractured ribs, and fractured sternum.
What exactly is a lacerated aorta?
Right, well, if this isn't clear, the aorta is the primary blood vessel which pumps blood from the heart to the rest of the body. So, essentially, if a body is moving at high speeds and comes to an abrupt stop, well, at this point we'll have to go all the way back to primary school physics. An object in motion will stay in motion unless acted upon. So, while the body is halted, the internal organs will continue to move in a constant motion. Now, if this force is significant enough, it can essentially rip the aorta from the heart, leading to almost certain death.
And in this case specifically, how did Rob Dillard sustain his lacerated aorta?
Right. We know the vehicle was moving at high speed, so when the airbag was deployed, it brought Mr. Rob Dillard's body to that abrupt halt. However, his internal organs continued to move in that constant motion, and this force was significant enough to lacerate his aorta. So he suffered an acceleration, deceleration injury.
Is there any other way Rob Dillard could have sustained that injury?
I'm familiar with Dr. Hopkins' conclusion that the impact with the telephone pole caused his lacerated aorta, but this is highly unlikely.
Why is this conclusion highly unlikely?
Well, we know that the vehicle did not come to an abrupt stop. In fact, the impact with the pole only served to redirect the vehicle's momentum. Therefore, this could not have been a significant enough force to lacerate an aorta.
So what do Rob Dillard's injuries tell us about his position in the vehicle during the accident?
Well, considering that his injuries are consistent with typical airbag deployment injuries, as they're all located in the general chest area, and the only side which the airbag was deployed was the driver's side, this places Mr. Rob Dillard most likely as the driver of the vehicle, and naturally Mr. Green as the passenger.
And what injuries did Daniel Green have?
Mr. Green's injuries were quite peculiar. You see, he suffered fractured ribs on the right side, a bruised and collapsed right lung, while his left lung remained entirely intact. Additionally, he suffered severe bruising on the superior segment of his liver, and just for context, the liver is located on the right side of the body. Additionally, he suffered severe bruising on his right kidney.
So what do all of these right side injuries tell us about Daniel Green's position in the vehicle during the accident?
We know that the passenger side of the vehicle is on the right side, so this would be the primary point of contact for anyone sitting in the passenger seat. Additionally, we also know that there was around a 12-inch deep intrusion into the passenger side door, so Mr. Green's injuries are very consistent with someone sitting in that passenger seat.
If Daniel Green's injuries are consistent with being in the passenger seat, why then was he found by firefighter Schrader in the driver's seat?
Ah, yes. So before the vehicle landed on all four wheels upright, it was leaning over on the driver's side, meaning that anyone still in the vehicle, which would have been Mr. Green, would then, by gravity, have been pulled down into the driver's seat, and then, with its momentum, teetered back over on all four wheels, and that is why Mr. Schrader found Mr. Green in the driver's seat.
Now, I'd like to talk about other interpretations of this accident. Why do you believe you and Dr. Hopkins came to such different conclusions?
Well, my investigation considered both possibilities of either Mr. Rob Dillard being the driver or the passenger. Well, Dr. Hopkins' conclusion was built on assumption and disregarded facts that would suggest otherwise.
What makes you say Dr. Hopkins' conclusion was built on assumption?
Well, we heard that Dr. Hopkins, before reviewing any of the physical evidence, was told that Mr. Green was the driver of the vehicle. And all Dr. Hopkins had to do was ask, but he didn't. And with no knowledge as to the validity of this assumption, he came to his conclusion. But a proper conclusion should be built on facts and data, not assumptions.
And what do the facts and data tell us about July 31st?
The facts and data tell us that to a reasonable degree of scientific certainty, Mr. Rob Dillard was the driver of the vehicle.
Thank you. No further questions, Your Honor.
Thank you. Cross-exam.
Yes, Your Honor. Dr. Friedman, I just want to first ask a few questions about your direct examination on how you testified that you worked 9 years as an accident reconstructionist.
Around 9 years as a private consultant.
And you said it was since 2014, correct?
Yes, I left the GBI in 2014 to redirect my focus on accident reconstruction.
Dr. Freeman, you made a statement today, correct?
I did, yes.
And you had a chance to review the statement, add anything substantial.
Your
this
Honor,
morning.
I'd be asked that I be shown the statement before Dr. Friedman is.
Your Honor.
Well, you may, before you ask the question of the contents, you must show it, but you're not at that point yet, so go ahead.
Yes, Your Honor. And you've had a chance to review the statement
I have, yes.
and add any substantial information if necessary.
Absolutely, yes.
Your Honor, at this time, according to the counsel, was previously been tendered as Dr. Tony Freeman's statement. Around, Dr. Freeman, I'm going to read portions of paragraph 9-2.
If it's all right, may I also have a copy just so I know what you're reading?
Do you have a copy?
Just read it.
Well, I believe it's important to have context, so if you
Okay,
read...
then I'll read it right here.
Thank you.
I'll read it.
Sorry
from
for the
here.
inconvenience.
Yeah. Okay, so I moved to Georgia in 2009
Mhm.
and started work at the Georgia Bureau of Investigation as a medical examiner, correct?
Yes.
I worked at the GBI for 7 years. You agree with that 9 plus 7 is 16, correct?
Yes. I will.
But you left the GBI at 2016, not 2014.
Oh, then yes, yes. Sorry,
Yes.
that was a...
So you weren't an accident reconstructionist since 2014, were you?
no, then it would be 2016. Apologies for the confusion.
Okay, so now let's get into the real line of questioning. Now, as a forensic pathologist, you knew not to make assumptions, correct?
Yes, my conclusion was based on facts and data.
And that's how you do your consulting work too. You look at the evidence and only testify to the opinions that you believe in.
No, I testified to what the facts and data tell us.
Yes, because that's where the evidence leads you to your conclusion.
Yes.
And you'd agree with me that it's important to get the right facts, correct?
Well, it's important to review all of the facts, yes.
Because if you rely on inaccurate or incomplete facts, that only undermines your opinion, correct?
Well, you can't always know for certain how valid a fact is, so you have to cross-reference it with other information. But yes.
Yes. So let's talk about the evidence that you were given by Triple M's lawyers when they hired you to give your opinion here today. Now, they gave you various articles, correct?
Yes, I reviewed some articles pertaining to similar circumstanced accidents.
Yes, about incidents where an occupant's death was believed to be caused by the deployment of an airbag.
Yes.
And those articles were not peer-reviewed, correct?
No, they were not, no.
You didn't conduct any independent research into whether airbag deployment can even cause an aortic rupture, have you?
Well, I've been working as a medical examiner, and I've worked on accident cases involving vehicle collisions, so I am very familiar with the lacerated aorta. And
But Dr. Freeman, in this case, Triple M's lawyers were your only source of information for airbag-related aortic injuries?
No, I've worked as a medical examiner, and I'm familiar with those types of injuries.
But you were provided by
Well-
those articles by
Yes.
Triple M's lawyers, correct?
So yes, they provided me with those articles, but I already was familiar with this type of injury.
Now let's talk about the things that you consider to reach your conclusion. Now, one of the facts that you consider was that the driver's side window was down, correct?
Yes.
And you relied on the accident report to get this fact?
Yes, I did.
At this time, approaching opposing counsel with what is previously been marked as Exhibit 11.
All right, 11 is noted.
Now, Dr. Freeman, this is the exhibit, the accident report that you reviewed, correct?
Yes.
Made by Officer Daystorm.
Correct.
Now, take a look at the narrative portion here. You'd agree with me that nowhere in this portion does it say that the driver's side window was down. Now, does it?
Yes, and I completely understand the confusion. After reviewing all the facts and evidence, it's clear that I misquoted from where I got that detail from. Yes.
And you went over your statement today.
I did, yes.
You still didn't catch that misquotation?
No, I did not. You see, I reviewed so much evidence, including photographs of the scene, so thinking about it, that's most likely where I reviewed this
So we
detail.
don't know how many misquotations you might have made, because you reviewed so many evidence.
No, that's not necessarily the case. This specific one, I misquoted from which piece of evidence I retained it. Yes.
Thank you, Dr. Freeman. Now, let's talk about how this accident occurred. Now, the Ford Focus fishtailed, correct?
Yes.
Counterclockwise?
Correct, yes.
And that means to the left.
Yes.
And you'd agree with me, because you took primary school physics, that if a car turns left, the occupants of the vehicle shift to the right?
Yes, but they're still within their seat, correct?
Yes, and so the passenger would be right up against that passenger seat, because as objects is motion, they still stay in motion until there's an object that stops that motion, correct?
Correct. And this is most likely how Mr. Daniel Green sustained a lot of his right side injuries.
And well, for the passenger seat, that object that stops the motion is the passenger side of the vehicle, correct?
Correct, yes.
Meaning that the passenger would be right up against that passenger seat, passenger door, I mean.
Correct, yes.
Correct. Now, that passenger door collided with a telephone pole.
Exactly. This is why Mr. Green's injuries are very consistent with him sitting in the passenger seat.
That's a yes, correct?
It is, yes.
And now, you'd agree with me that if a car's passenger side door is acted upon with a force, the person right up against that passenger seat will suffer the brunt of that force, correct? Because
Yes.
they're right up against that door that collides.
Precisely, yes.
In this case, Rob Dillard died, correct?
Yes, he did, yes.
Danny Green lived.
Yes, he did.
And again, the passenger suffers the brunt of the injury.
Yes, correct. But we also know that the impact was only to redirect the vehicle's momentum. It did not come to an abrupt stop.
Thank you, Dr. Freeman. Now, you were paid $26,400 for your testimony to this jury, correct?
I was, yes.
$600 per hour for review of evidence.
Yes, I am paid for my skilled private consultation, as you and your co-counsel are paid for your skilled trial work. Yes.
$7,500 for your testimony to this jury,
Precisely, yes.
summing to $26,400.
Yes, but just to be clear, my testimony is not on behalf of the defense's theory, it's on behalf of the facts and data.
Okay, so the Triple M, the defense, gave you $26,400.
Yes, for my work as a private consultant.
They also gave you all the evidence.
Yes, they provided me with evidence.
No further questions, Your Honor.
Well, thank you. Redirect.
Yes, Your Honor, may I first inquire as to how much time the defense has left on direct?
The defense has 2 minutes and 36 seconds remaining.
Briefly, Your Honor. Dr. Friedman, would your conclusion have been different if the driver's side window had been rolled up?
No, because in my initial investigation, I always considered both possibilities, of either the driver's side window being down or up. The fact that I had believed it to say it in the accident report did not make it an actual fact. So I cross-referenced that information with the actual physical evidence to come to my conclusion.
And why did Rob Dillard sustain more severe injuries than Danny Green?
Because when the vehicle stopped, the abrupt stop of the airbag caused the lacerated aorta.
No further questions.
Recross.
May I ask for a time check if I do have time for my class?
30 seconds.
Okay. Dr. Freeman, you can't tell us about when this airbag deployed, correct?
It was most likely deployed when the vehicle made impact with the passenger side of the pole.
You also can't tell us about any frontal impact to this car, correct?
No, I cannot.
You can only tell us about the force of the telephone pole?
Yes, I'm reconstructing the accident, so it's important to consider all possibilities. Yeah.
And Rob Dillard was right up against that passenger door.
No, incorrect. He was in the driver's seat, driving the vehicle.
No further questions, Your Honor.
All right, thank you. May the witness be excused?
Yes, Your Honor.
All right, you may step down. Thank you.
At this time, the defense rests, Your Honor.
The defense is rested. I believe under the procedural rules of this jurisdiction, the plaintiff may open the closing argument and reserve time for rebuttal, or may reserve all of its time for rebuttal, which you choose to do.
Firstly, I will do my first portion of my closing and then reserve any additional time left to proceed with the rebuttal of defense's closing.
Very well. You may,
But before I do that, may I position exhibits as necessary
you
on the
can
jury?
collect anything you need to collect for closing, sure.
Can I see your ID? One simple request. All Farnsworth had to do was ask. She didn't, and Rob is dead as a result. As the plaintiff, we bore the burden. So to justify you rendering a verdict in our favor, we have to prove by preponderance of the evidence that the defendants unlawfully, willfully, and knowingly sold alcohol to Green, and this so knowing he would be driving soon. Here, the preponderance of the evidence simply means more likely than not. A scale of 50-50 plus a feather. Our evidence is more than a feather, and the scale is tipped in our favor. As to the beer sale, the first two prongs, unlawfully and willfully, are not in dispute. Green was under 21 when Farnsworth sold him the beer, and Farnsworth did so of her own volition. Now the final prong, knowingly, is what you, members of the jury, must determine. In a moment, the court will instruct you that proof of actual knowledge is not required. If Farnsworth, by exercising reasonable care, should have known that Green was under 21, then she esteemed that knowledge of that fact. And well, even with this sign hanging in the Triple M, her own store, on July 31st, Farnsworth still made that sale. Not once, not twice, but more than 20 times. And she offered self-serving testimony here today that Green looks not a day younger than 25. Well, 25 is clearly not 30. So Carter, just like the sign says. As to whether Farnsworth knew that Green would be driving soon, Green was a regular customer who never walked to Triple M, and he didn't walk there on the 31st either. He drove there so often that Farnsworth even knew what kind of car he drove, a small, red, American-made car. Now, Green pulled 2 six-packs from the cooler, and he told Farnsworth that he was going to have a relaxing evening with his friends. Members of the jury, when you go into that jury room today, you take your common sense with you. One, it was already evening. It was 7 p.m. the second time he came into the Triple M. Green chose cold beer. Common sense tells you that Green was already on that way to that good time with friends. And Farnsworth should have known. All these unlawful, willful, and knowing sale of alcohol to Danny Green made a predictable and continuous chain of events. Green drank that beer, and that made him unsafe to drive when he tried to drive off home. Rob never made it home. Instead, he went to the morgue. I'll have one last opportunity to speak with you after defense counsel gives their closing. If they try to blame the victim, suggesting that Rob assumed the risk, remember that they have to prove by preponderance of the evidence that Rob had both actual and subjective knowledge of the specific risk of getting in that car. They can't.
All right, thank you. Defense.
Yes, Your Honor. Permission to proceed?
You may.
The death of Rob Dillard was a tragedy. Jordan Dillard is grieving, so in an attempt to cope with the loss of his brother, he's blamed my client for the accident, Casey Farnsworth. Now the grief Mr. Dillard feels is understandable, but at the conclusion of today's trial, Judge Carbo will tell you, no matter how bad you may feel for Jordan Dillard or his situation, your verdict today should not be based on sympathy, but on facts. And the fact is, Casey Farnsworth had no knowledge, no warning, and therefore is not liable. This is because for Ms. Farnsworth to be liable for the accident on August 1st, the plaintiff had to prove 3 things. that Miss Farnsworth knew Danny Green was underage when she sold to him, that Miss Farnsworth knew Danny Green would later be behind the wheel, and that it was Danny Green driving the time of the accident. But they have failed to meet their burden. What Casey Farnsworth does know July 31st is the lie that Danny Green tells her, that he's excited for a relaxing evening. Now, the plaintiff has asked you to believe that Miss Farnsworth should have known this was a lie, that somehow Miss Farnsworth should have seen 7 hours into the future and known Danny Green would be going to a party. But unlike the plaintiff, Georgia law does not ask business owners to read minds or to see into the future. It asks them to act reasonably with the information that they have. And that's exactly what Casey Farnsworth did. Georgia law only requires vendors to check identification if they could reasonably be in doubt that their customer was 21. There was one fact in today's case that the plaintiff and the defendant agreed on. Jordan Dillard told you himself. July 31st of 2021, Danny Green looked over than 21. Casey Farnsworth also told you. July 31st of 2021, Danny Green looked older than 21. And when Mr. Green himself is asked how he's able to purchase alcohol from the market, his response, I just look old enough. Now the truth is, there's one person who knew Danny Green was underage, and that's Jordan Dillard, who observed a sale between Green and Farnsworth weeks before the accident even happened and said nothing. All Jordan Dillard had to do was tell Miss Farnsworth that Danny Green was underage. But Jordan Dillard gave no warning, so Casey Farnsworth had no knowledge. Now to meet their burden today, the plaintiff had to prove Danny Green was driving the time of the accident. But remember, members of the jury, you heard from Danny Green's deposition. He does not remember the crash itself taking place. We know Rob Dillard was the driver because Simone Bello, the only person who actually saw the crash happen, but she knows what she saw, which is Rob Dillard ejected from the driver's side of the vehicle. The plaintiff's, Dr. Hopkins, well, he only knows what he's told. An officer tells Dr. Hopkins that Rob Dillard is the passenger, and Hopkins looks to confirm the officer's conclusion instead of coming to his own. In fact, he sat right here and he told you that he reviewed photos taken by the first responders, but Charlie Schrader told you that the first responders don't take photos of the scene, and in fact, he didn't take photos of the scene. But Dr. Friedman considers both possibilities, and he comes to the conclusion that the physical evidence and the eyewitness testimony line up with, that the deployment of the driver's side airbag is what caused the lacerated aorta of the driver, Rob Dillard. Rob Dillard died as a result of Rob Dillard's own actions. Casey Farnsworth never sold any alcohol to Rob Dillard, and she cannot be liable for those actions. Now, the burden that rests upon the plaintiff today is the preponderance of the evidence, meaning more likely than not. So what's more likely? That Casey Farnsworth purposely sold alcohol to someone underage, knowing that they were underage, knowing that they would later be going to a party, knowing that there was a possibility of them later driving, that Casey Farnsworth believed Danny Green was at least 25 because that's how old he looked. That Casey Farnsworth believed Danny Green would be going home and having a relaxing evening because that's what Danny Green told her. The plaintiff has failed to prove that Danny Green was driving, that Casey Farnsworth knew Danny Green was underage, or that Casey Farnsworth knew if Danny Green would later be behind the wheel, because Casey Farnsworth had no knowledge and no warning. And that is why I stand before you and ask you to return a verdict that truth demands and justice requires, to find Casey Farnsworth and the Miltonville Mini Market not liable. Thank you.
Thank you very much. Plaintiff, you have time for rebuttal.
Yes, Your Honor. No knowledge, no warning, no liability. Now that's what defense counsel wants you to believe. But there was, quite frankly, a very simple solution to that, wasn't there? Can I see your ID? That's all it took. Then she would have knowledge, and she would not be liable here today. But she didn't, which is why she is liable. We told you defense would blame the victim. We were wrong. They didn't only blame the victim. They blamed Mr. Schrader. They blamed Dr. Hopkins. But they failed to blame the only person that there is to blame, Miss Farnsworth. So let's talk about who was driving that car. In a moment, the court will charge you on the presumption of continuity. A state of things proved to have once existed is presumed to have continued until evidence proves otherwise. Now, Green was asked, who drove? And he said, I did. When Schrader arrived at the scene, he found Green in the driver's seat. Green was driving. And Bello and Dr. Friedman failed to disprove this continuity. Miss Bello thinks Rob was ejected out the driver's side window. But remember, she admitted it all happened very fast. She was buzzed. She was half asleep. Her opinion is simply a guess, not a rationally based perception. Dr. Friedman bent the truth to get to the conclusion that the defendants paid him $26,400 for it. That incident report didn't say that the driver's side window was down. He said it was a simple misquotation, but that driver's side window wasn't down. He made it up to fit his theory. In the end, members of the jury, all Miss Farnsworth had to do was ask. She didn't, and Rob is dead, as her son. We ask you to reach a verdict in favor of the plaintiff. Thank you.
Thank you very much. All right, that concludes the round. Good job, everyone. Let's give a couple of housekeeping matters first. Does either party contend that their opponent has committed any inside the bar rules violations?
None from the plaintiff, Your Honor.
None from the defense, Your Honor.
You just made my job a lot easier. I appreciate that. Thank you. All right, this time we're going to dismiss the evaluators to the jury room to complete their ballots. I will join you very shortly. I believe that you've been given forms for outstanding performance on the opposing sides. While we step out, discuss those, we will have you announce those when we come back in. At this point, I'm going to join the evaluators. We will return in a few moments. I don't believe we're going to give any comments. We're just going to introduce ourselves, let you know who we are, and then the results will be announced. But again, great job. We'll see you in just a few moments.
Thank you.
Your Honor.
Your Honor, would you like time?
Yes, let me get the time. There were no times. We just asked. There were no time discrepancies.
No.
Great job. Thank you. We'll take it. Couple of things we're going to do before they come. They're still totaling up the ballots over there, but we're going to do a couple of things in the interest of time. We're still waiting on a couple of yours. Here they come. That's all right. We'll have the contempt hearing shortly after. First of all, again, great job, everyone. We're going to introduce ourselves very briefly so you'll know who we are. Again, I'm John Carbo. I'm a senior state court judge. All that means is I know a lot of stuff, but I don't know the meaning of the word retired. I actually retired in 2017, but I'm still working pretty regularly on a fill-in basis. But for this discussion, the more important thing is probably that I spent 24 years coaching at the high school level, stopped that at the end of 2023. And now I coach at the law school level at Mercer University, which, shameless plug, has the #2 ranked mock trial program in the country among law schools. So if you're thinking about law school, Mercer's got a great advocacy program. So let's just get introductions around from everyone.
I guess I get to go first. Faith Worley. I work at the Attorney General's office, competed in high school mock, am on the committee, retiring from my committee chair position at the end of the summer. So, but always great to be here and see all the work you guys put in.
Alicia Vale Taylor. I just started my own law firm, the Avail Firm, practicing family law, estate planning, and personal injury. I was faculty at Law Academy. I was a mock trialer like you all. I also went to Law Academy, so I lead mock trial. I love what you guys have been doing with the program. It is fantastic. It has improved tremendously. So great job. If you see me around, I'm mostly in Decatur area. The office is outside of the Beltline area, so if you're around, have any questions, any internships, questions, whatever, just make sure to find me, let me know. Yeah, great job.
Thank you.
My name is Josh Schiffer, longtime Giants scorer fan, former coach of mock trial. I'm a criminal defense and plaintiff's work out of my office in Roswell and the U.S. Virgin Islands. I do a ton of television stuff, and this is the best thing our Georgia bar does because it identifies y'all's next step is to take over and to fix everything when we're done. And y'all are doing a spectacular job. This competition gets better every year. I've been doing this for over 20 years. You have an enormous amount to be proud of and thankful for the judges, coaches, and your parents for getting here. You guys are the best, so keep doing it.
My name is Jeff Fulbright. I have been practicing law for just over 33 years now. I'm licensed to practice in Georgia, Texas, and Colorado. I started out my career as a trial lawyer at a big law firm in Dallas, Texas. I tried cases for 7 years, 3 trials, and then I went in-house. So I'm in-house. I'm a corporate counsel for an international company, and so I basically, when we get sued or we have lawsuits, various in the U.S. and other countries, then I hire outside counsel to go to court for us now, so I don't go to court anymore, but I'm heavily involved in it. I was also a mock trial coach. My kids all were part of the program. We did that back in 2013 and 14 and 15, and we went to the state championships twice, and I had 4 of my kids, and they were all part of the program, and I graduated from the University of Georgia, and they still talk about mock trial and the funny things, and I was calling 2 of them today. I said, hey, I'm going down, and I'm a judge of the state finals. I'm pumped about it. It's a great program. I know what the coaches do, and I know what the students do. It is a ton of work. You guys were phenomenal. I mean, I literally, when I was scoring, I couldn't believe. I was stunned at how good you guys were. And I was thinking, and I've been doing this since 2000, I've been doing the judging, I've been a presiding judge, and I've done all that. I've been doing it since 2011, I think was the first year I did it. So what, 13 years now? This was the hardest round for me to judge. It really was. You guys were so good, and it was so close. It was phenomenal. I mean, I'm blown away, and I can't wait to pick up the phone. You guys don't know this is phone anymore, but I can't wait to get and talk to my kids and tell them I just saw the 2 amazing teams. I love this program. You guys have tons to be proud of.
First of all, big round of applause for everyone here. The witnesses, the families, the supports, the coaches, everyone, amazing job. My name is Eric Frisch. I am a partner in the law firm of Copeland, Stair, Valls, and Lovell. Been practicing since 1996. My law school classmate over there knows what a terrible law student I was. I have represented people who have been injured in by negligence before for the first part of my career, and then since 2001 I've been defending folks in civil lawsuits, mostly healthcare providers and legal professionals. Actually, let's try the case about 2 years ago on very similar issues involving the seatbelt sign and a lacerated viscous injury. And I just tried a case 2 weeks ago, and it was supposed to start a trial yesterday, but we ended up settling it, and so I was fortunate to be here with you. I'm also a mediator and an arbitrator, and looking forward to launching that as the most substantial part of my career going forward. But I echo everybody's comments so far. I've been judging this since about 1997, and it gets better each time, and you all were phenomenal. Really appreciate it, and thank you for the opportunity to watch this today.
Hey everybody, my name's Alan Lightcap. I'm a small firm trial lawyer in Atlanta. I'm also a coordinator for this program, and I'm a former coach. And as a former coach, I recognize the incredible dedication that y'all's coaches have made to teach y'all the rules of evidence, the way of presenting a case, and it's really remarkable what y'all's coaches have been able to do and what you have been able to take from that. I just want to say thank you. I really, what happened in this room today represents the culmination of hundreds, if not thousands of hours of the people that are in this room, and you could really tell. It was so amazing.
Thank you, Judge Carver. So hello, everyone. I'm Ashley Palmer. I serve as a judge in Cobb County on the state court. Once upon a time, Judge Carver was one of my judges, and now he's one of my colleagues. It's been a cool circle moment. So I have been former chair of the high school mock trial committee. I was a regional coordinator for both Atlanta, and now I'm the regional coordinator in Cobb. And in my court, we do criminal misdemeanors as well as civil actions, much like what we just saw here. So if y'all are ever on the square, come see me. I'm right on the first floor, the best courtroom. So.
Thank you. I understand we've got a couple of awards we need to deal with. First of all, the teams have awarded an outstanding performer from each side. We'll start with the plaintiff, and you can announce your outstanding performance award.
Yes, Your Honor. The plaintiff presents this award to Lila Didier.
Does the defense have an award?
The defense has the award for Rachel Lee.
All right, and we have a couple, I'll come around here and do that. I've got to come back up here, but I'll come back around here to do this. We have a couple of individual awards to hand out. First, for the outstanding witness in the state championship round for 2025 goes to Ben Hastings. And the outstanding attorney award for the state finals championship round goes to Rachel Lee. Court's going to go back in session right now. So somebody found it. All right. I understand at this time, Mr. Foreman, has the jury reached a verdict in this case?
We have.
All right. If you will hand the verdict form first to the bailiff so I can inspect it for proper form. I have to open this thing. By the way, one more comment. This is my 14th state championship round. The first 13 were sitting out there. This is a lot more fun. All right. All right. And it does appear to be in proper form. And I'll hand it to the bailiff to hand back to the jury foreman, who will announce the verdict.
All right. The 2025 state champion for high school mock trial is Decatur High School.
I could tell by your
Anybody ever wants to go to lunch? I have a limited lunch budget. I really have none. Well, okay. My office is in Roswell. I live uptown now. No, I go downtown, I go uptown.
That's what I thought, because I know who I voted for. Yes. Yes.